The 21st of October 2025, we are proceeding with the matter of Mengo versus Mbenenge. It's only just over 11:30. Apologies. There has been confusion about whether or not we are commencing or resuming today or tomorrow on the part of one member of the tribunal. But upon realizing that we are resuming today, he tried his best to arrive in time. And I told you in chambers that he said he would arrive between 11 and 11:30 because he was coming to Pretoria. So indeed, he has arrived in time. So we are resuming today, and Counsel can assume that in making their submissions that we have read their written argument, and that as and when they begin with their submissions, they must do so against that background. They are free to argue the matter in the way that they prefer best, whether to highlight certain points and which ones and so forth and so on, as long as they understand that we have read their heads of argument. Advocate Scheepers.
Thank you, Chair. Chair and honourable members of the tribunal, this tribunal has been convened pursuant to the determination of the Judicial Conduct Committee, which found that a prima facie case of gross misconduct exists against Judge President Selby Mbenenge. The establishment of this tribunal is therefore not a mere formality, it is a constitutional imperative. The task before this tribunal goes far beyond administrative inquiry. It represents a crucial test of the judiciary's integrity and its commitment to the foundational values of the Constitution, which is dignity, equality, and accountability. The outcome of these proceedings will speak to the very heart of public trust in the judiciary. It will demonstrate whether our system of justice has the courage to hold even its most senior members accountable when confronted with serious allegations of misconduct. The central issue in this matter for determination is clear: whether the conduct of the Judge President constitutes sexual harassment and whether that conduct amounts to gross misconduct within the meaning of the Judicial Service Commission Act and the Code of the Judicial Conduct. It is common cause that the respondent, Judge President Mbenenge, sent sexually charged WhatsApp messages and unsolicited images to the complainant, Ms. Andiswa Mengo, a judge's secretary. The defense advanced by the respondent that he misread signals or misunderstood intentions does not withstand legal scrutiny. The proper test is not his subjective belief, but an objective one, viewed through the eyes of a reasonable person. Did his conduct breach the Code of Judicial Conduct, and did it undermine public confidence in the integrity of the judiciary? If we look at the evidence of the complainant, what emerges from this body of evidence is a deeply troubling pattern of behavior. It was persistent and unwanted and inappropriate advances from a senior judicial officer towards a subordinate employee. The implications of such conduct go far beyond the personal. They strike at the principle of equality in the workplace, the right of women to dignity and security, and the constitutional expectation that judicial officers will embody the highest standards of ethical behavior, both in and out of court. The complainant, Ms. Andiswa Mengo, provided detailed testimony. She described the discomfort and emotional distress she experienced as a result of the respondent's persistent advances which she repeatedly attempted to deter. The WhatsApp messages corroborate her version. They show that the respondent initiated the majority of the conversations, steered them from neutral topics to sexual themes, ignored attempts to disengage, and even sent unsolicited sexual images. The complainant never initiated intimate discussions. She used politeness, humor, and silence to deflect discomfort, not to invite it. She eventually blocked the respondent in an attempt to maintain professional boundaries. Her testimony reflected not only distress, but the heavy burden of navigating an unequal power dynamic. Her account found support from several witnesses. Importantly, she testified that she initially refrained from lodging a complaint due to fear of retaliation and the respondent's seniority. She only later reported the conduct to the court management, sought mediation, and only escalated the complaint when informal processes failed. These are not the actions of a malicious accuser. They are the careful, hesitant steps of a woman balancing fear, duty, and integrity. The digital forensic expert, Mr. Moller, confirmed that he downloaded messages from the complainant's handset. He testified that the deleted messages are irretrievable due to the fact that it was overwritten. But the fact of deletion itself is significant. The complainant preserved the messages on her device. The respondent did not. A crucial aspect of his evidence is that the absence of messages due to deletion does not mean the content never existed. This is especially noteworthy in cases of sexual harassment, which often occur in private and are seldom witnessed. Dr. Zakira Dokrat, the forensic and legal linguist, provided uncontested expertise in social linguistics and the semiotics of emojis. Her analysis showed a clear escalation in tone, from professional exchanges to overtly sexual communication. The respondent's messages employed explicit emojis, for instance, the eggplant, the peach, and the licking lips, universally recognized as sexualized symbols. The complainant's laughter and see no evil emojis reflected discomfort, not complicity. She testified that context is paramount. Emojis cannot be interpreted in isolation. The meaning depends on the conversation flow, cultural background, and the relationship between the sender and the recipient. Under cross-examination, Dr. Dokrat was firm. Viewed objectively, these messages could not plausibly be construed as platonic. Her findings align perfectly with the complainant's account that the messages received from the respondent were unwanted. Ms. Kutlwani Moretlo, a former state law advisor at the JSC, was instrumental in formalizing the complaint against the JP. Her evidence provides procedural certainty and institutional legitimacy to the manner in which the complaint was lodged. She testified that on the 7th of December 2022, she assisted Ms. Mengo in the drafting of the complaint, carefully recording her narrative and cross-referencing WhatsApp messages for accuracy. When the process could not be completed that night, the draft was saved to a memory stick for finalization. The next day, the document was returned by Ms. Mengo, printed, signed, and properly commissioned on the official JSC platform. Ms. Moretlo explained that although the original complaint was later misplaced after being handed to the Chief Justice, it was never rejected or deemed inadequate. The complainant was simply asked to resubmit it in affidavit form with clearer references to the messages. This second reformatted version was duly couriered and submitted in January 2023, confirming full procedural compliance. Crucially, Ms. Moretlo made it clear that she had no personal interest in the matter. Her involvement was purely administrative, assisting a complainant to navigate the official JSC process. Her testimony therefore reinforces the integrity and authenticity of the complaint initiation and handling. Mr. Abongile Chete, Judge's Secretary at the Mthatha High Court, provided an independent and balanced account that lends further credibility to the sequence of the event. He testified that he first became aware of the issue when he saw the screenshots of WhatsApp conversations between the complainant and the Judge President posted on Ms. Mengo's WhatsApp status. Although the complainant's responses had been deleted, the posts confirmed that such communication had taken place. Shortly thereafter, the Judge President contacted him, ostensibly on work matters, but during the conversation appeared visibly anxious and admitted that the situation was affecting his health. He even sought Mr. Chetty's assistance to arrange a mediated meeting with Ms. Mengo, which she declined. Mr. Chetty described the Judge President as someone who often referred to himself as a father figure and who frequently communicated with secretaries after hours, mainly about work, but at times on personal issues, a pattern that sheds light on his interpersonal approach and boundaries with subordinates. He also assisted Ms. Mengo by advising her on how to proceed formally, but was careful to remain neutral and uninvolved beyond offering guidance. Importantly, Mr. Chetty harbored no personal conflict with either party and did not claim to have witnessed misconduct himself. His testimony was measured, credible, and reflective of a neutral intermediary attempting to assist both sides in a sensitive situation. Ms. Ntombokolo Brenda Jobela is the judge's secretary based at Kaberga High Court and formerly served as a secretary to the Judge President, the respondent in this matter. Her testimony provides critical corroborative evidence regarding the complainant's early disclosures and the nature of the material she shared with trusted colleagues. Ms. Jobela testified that she received 3 images via WhatsApp from the complainant, Ms. Mengo. The first was a screenshot of a WhatsApp conversation between Ms. Mengo and her late colleague, which included an image of a man's private parts. The second was a motion picture or animated GIF depicting a sexual act. The third was a photograph of a man's leg taken in what was later identified as the JP's chambers. These images were transmitted to her without accompanying commentary, suggesting that the complainant sought to show rather than describe what she experienced. Importantly, Ms. Jobela clarified that the explicit image forming part of the record as Exhibit K8 was not the exact image sent to her. Rather, she received a screenshot of a screenshot containing superimposed text, specifically from a conversation between the complainant and the late colleague. This nuance demonstrates the complainant's consistent use of secondary screenshots as a means of documenting her exchanges while preserving the evidentiary chain of the original material. Ms. Jobela further testified that when the complainant first approached her, she stated that an older judge was harassing her, but not at that stage identified the Judge President by name. Concerned by the allegation, Ms. Jobela took it upon herself to confront one of the other senior judges, believing he might have been implicated. She even showed him the images, whereupon he firmly denied any involvement, stating that Ms. Mengo was like his child. Ms. Jobela's evidence is highly significant. It demonstrates that the complainant confided in a colleague well before the matter became public, that she shared corroborating material contemporaneously, and that her disclosure was not fabricated after the fact. It further illustrates her distress and uncertainty about how to proceed in this hierarchical environment where even trusted colleagues could also be potentially authority figures. Her testimony therefore corroborates both the existence of the images and the complainant's consistent narrative regarding unwanted sexualized conduct by a senior judicial officer. It shows that the complainant's actions were consistent with the victim seeking support and validation, not out of malice toward the respondent. Mr. Denham Krokwana, the Director of Court Operations in the Eastern Cape, testified to his direct involvement after the complainant informally raised concerns about the respondent's conduct. His evidence provides institutional confirmation that the matter was reported and taken seriously within the judiciary's administrative structures even before the formal complaint was filed. Mr. Krokwana testified that in late November 2022, the complainant approached him and reported that the Judge President had sent her inappropriate messages. She further related an incident that had occurred in the Judge President's chambers around 14 or 15 November 2022, during which he allegedly remarked to her, "You should see the effect you have on me." This statement, if accepted, reveals conduct that is both inappropriate and sexually suggestive, and entirely inconsistent with the decorum expected of a judicial leader. The complainant also indicated to Mr. Qukwana that she sought an apology from the Judge President and proposed that the matter be addressed through a mediated roundtable discussion involving female judges. This proposal underscores her initial preference for a restorative rather than adversarial approach, consistent with a complainant who is distressed yet respectful of institutional processes. Mr. Qukwana testified that this proposed roundtable was ultimately abandoned after the complainant publicly posted excerpts of her WhatsApp exchanges with the Judge President on her WhatsApp status. Following this development, Mr. Qukwana advised her to pursue a formal complaint through appropriate channels, guidance which ultimately led to the complaint being lodged with the Judicial Service Commission. The importance of Mr. Qukwana's testimony lies in its corroboration of key factual elements. First, that the complainant made an early and consistent report of inappropriate conduct. Second, that her account of the incident in Chambers predates any public disclosure. And third, that the matter was handled with seriousness and procedural propriety at administrative level. Mr. Naidu testified on the CCTV system. Then I will go to Ms. Lisa Vetten. She was called as an expert witness to assist this tribunal in understanding the broader social and psychological context within which acts of sexual harassment typically occur, particularly where there exists a profound imbalance of power, such as between a Judge President and a junior staff member. Ms. Vetten is a well-recognized authority in the field of gender-based violence, with over 25 years of experience in research, policy, and advocacy on violence against women in South Africa. Her work has consistently engaged with the dynamics of sexual harassment, power, and institutional responses, making her uniquely placed to assist this tribunal in interpreting the complainant's experience. Ms. Vetten explained that sexual harassment is not fundamentally about sexual desire. It is about power. It often occurs in environments where one individual wields significant authority over another. The conduct, though sexual in nature, functions as a mechanism of asserting dominance, control, and entitlement, thereby affecting the dignity, well-being, and working conditions of the complainant. She described how perpetrators frequently employ grooming techniques, beginning with flattery, seeming innocuous familiarity, or manipulative kindness, gradually escalating to more personal and inappropriate behavior. This progression creates confusion and discomfort for the victim, who often struggles to reconcile the conduct with the norms of a professional relationship. Drawing on extensive social science research, Ms. Vetten clarified that victims of sexual harassment rarely respond with immediate confrontation or formal complaints. Instead, they may attempt to deflect the advances politely, maintain cordial communication to avoid retaliation, or even continue seemingly friendly interactions out of fear of professional repercussions or reputational harm. Importantly, she emphasized that such behavior, including delayed reporting or polite replies, does not amount to consent, nor does it undermine the complainant's credibility. Rather, it is consistent with known patterns of coping and survival in contexts of unequal power. Ms. Vetten situated this case within the distinctive environment of the judiciary, where authority is both formal and deeply hierarchical. She testified that a judge president wields substantial institutional influence, enough to make any junior employee fearful of the consequences of resistance. Within such a structure, there are few safe or accessible channels for reporting misconduct, and a culture of deference to authority compounds the victim's sense of vulnerability and isolation. Turning to the WhatsApp exchanges between the complainant and the respondent, Ms. Vetten provided critical insight. She observed that the complainant's responses were often strategically polite or evasive, an effort she suggested to placate the respondent without confrontation. Several of the respondent's messages contained sexual innuendo or inappropriate familiarity, inconsistent with a professional relationship. According to Ms. Wetten, these communications reflect a grooming pattern, where rapport was first established and then progressively sexualized, a well-documented trajectory in cases of workplace sexual harassment. Her evidence further reinforces that apparent friendliness or humor in the complainant's replies cannot be taken at face value. When viewed through the lens of trauma-informed evidence-based research, such behavior aligns with established victim responses to harassment by a superior. Ms. Wetten's expert testimony provides a credible and scholarly framework through which the complainant's conduct and the tone of her communications must be understood. It underscores that compliance, politeness, or the absence of outright refusal does not signify consent. Rather, these are hallmarks of a victim navigating an unequal and intimidating power dynamic. It is therefore respectfully submitted that Ms. Wetten's evidence supports the conclusion that the complainant's account is not only plausible but consistent with established patterns observed in sexual harassment cases involving individuals of high authority. Her testimony affirms that what transpired here reflects the dynamics of power and control that underpins such misconduct, and that the complainant's responses were entirely typical of a victim attempting to preserve her safety, dignity, and livelihood within the profoundly unequal relationship. If we look at the evidence on behalf of the respondent, Ms. Nkayi testified regarding the alleged incident of 28 May 2021 that she did not witness the Judge President hugging the court manager, Ms. Tambudala. However, during cross-examination, she conceded that such an incident could have occurred during a time when she was not in her office. Although she initially claimed to have been at her desk throughout the relevant period, she later admitted that she occasionally left her workstation, for example, to fetch files or use the bathroom. Concerning the alleged incident of 14 November 2022, Ms. Nkayi confirmed that the JP made comments about the complainant's attire, though she attempted to minimize their significance by describing them as part of the JP's daily talk. She noted that the Judge President's chambers had two entrances, one of which was accessible through her office, thereby acknowledging that interactions could have occurred without her knowledge, even when she was present. She maintained that she left the office on that day, the 14th of November, after the complainant. However, the complainant testified that they met at the bed and breakfast. Although the laptop register reflects that the complainant signed out 11 minutes earlier than Ms. Nkayi, this does not preclude the possibility that Ms. Nkayi could have arrived at the B&B before her. There is no evidence suggesting that the complainant departed the court premises immediately after signing out the laptop, nor is there clarity on whether they traveled the same route. Ms. Nkayi's claim that her clothing was already packed in the vehicle is improbable, given her own assertion that she only learned she would not be returning to Mutata that afternoon at 16:15. It is respectfully submitted that it is implausible for the witness to recall the level of detail reflected in her testimony, particularly when she made no contemporaneous record of the events and only drafted a statement nearly 2 years later. Notably, her written statement contains no mention of the alleged incident of 28 May 2021. Yet in her oral evidence, she purported to remember specific details of that day, such as being unable to reach the court manager telephonically and deciding to walk to her office to call her. It is further respectfully submitted that Ms. Nkayi's evidence does not contradict or disprove the complainant's version. Overall, her testimony is marked by improbabilities and indications of bias. Her evidence fails to rebut the complainant's allegations and in certain respects inadvertently corroborates them, for instance by confirming the JP's inappropriate commentary on the complainant's attire. It is therefore respectfully submitted that the tribunal should attach limited weight to her testimony. The next witness called on behalf of the respondent, Dr. Vincent Mello, respectfully did not take the matter further. It is respectfully submitted that Dr. Mello is not an expert qualified to interpret the use of emojis within a legal or forensic context. He is neither a forensic linguist nor a legal communication specialist. He confirmed under oath that membership of the Unicode Consortium, the body that standardizes emoji meanings, is open to anyone upon application and payment of a fee, without the need for any academic qualifications or expertise. As such, his affiliation does not confer any particular authority or expertise in the interpretation of emoji usage in legal proceedings. Crucially, Dr. Mbenenge conceded that the emojis exchanged between the complainant and the respondent were not always used in accordance with their standard Unicode meanings, thereby undermining the reliability and relevance of any conclusions drawn from their appearance in the messages. In respect of the disputed messages, namely Annexures H1 and H2, K8, N, and P, Dr. Mbenenge further conceded that based on the evidence before him, he was unable to determine the original sender or recipient of these messages. This concession renders his testimony of limited probative value, particularly on the issues central to the respondent's denial of misconduct. When we turn to the evidence of the respondent, Judge President Mbenenge, we are confronted with a version that is riddled with improbabilities, evasions, and contradictions. His testimony, rather than rebutting the complainant's account, only reinforces it. The respondent sought to portray his interactions with the complainant as a harmless, even culturally grounded form of flirtation, suggesting that he was merely expressing interest in a manner consistent with Xhosa customs. Yet when pressed under cross-examination, he could not articulate what this interest actually meant. At one moment it was a flirtation, at another it was a courting process. But in the very first WhatsApp conversation he had with the complainant, he asked her to send a naked picture, take off the top part. Honourable members, this is not a cultural overture. It is a sexual solicitation. It stands in direct contradiction to his claim that his conduct was innocent, respectful, or culturally appropriate. The respondent also told this tribunal that he would read the room, that he would somehow gauge from the complainant's responses whether his advances were welcome. But the record of the messages paints an entirely different picture. He was the one who repeatedly initiated sexualized conversations. He ignored the complainant's polite attempts to change the subject, and when she fell silent, he took that silence as consent. Even after weeks of no communication, he reignited the sexual dialogue, entirely unprompted. These are not the actions of a man reading the room. They are the actions of a man assumed consent where none existed. He further attempted to normalize his conduct by telling this tribunal that judges have relationships with secretaries and some even marry them. That statement is profoundly troubling. It shows a complete misunderstanding or disregard of the power imbalance inherent in the relationship between a judge president and a subordinate staff member. There is no evidence here of mutuality, no evidence of reciprocal affection. What we see is a senior judicial officer leveraging his position to persuade a vulnerable junior employee. On the issue of the 14th of November 2022, the respondent relied heavily on CCTV footage, which by his own admission was incomplete, lacked timestamps, and had significant gaps. His own movements are not visible. In other words, the footage cannot disprove the complainant's version. On the other hand, the complainant gave a clear, detailed, and consistent account of what occurred, an account that aligns with the immediate emotional reaction and the steps she took afterwards. The respondent's denial of having sent a sexually explicit image is equally implausible. When confronted with his reply, "Yours, please," sent immediately after an exchange about nude photographs, he could offer no reasonable explanation. That is not the response of someone unaware of what is being discussed. Throughout his testimony, the respondent leaned heavily on his reputation, his years of service, his leadership role, his record as a judicial officer. But professional stature does not place anyone above accountability. Indeed, it demands a higher standard of conduct. The evidence shows that his behavior was deliberate, sustained, and exploitative. He asked for messages to be deleted. He worried about his family finding out, and he sought to recast his messages as something other than what they plainly were. Those are not the actions of an innocent man. They are the actions of someone conscious of wrongdoing. In the end, the respondent's version is not only improbable, it is untenable. His explanations shifted as the evidence mounted against him. His cultural justifications were opportunistic, invoked only when convenient. His denials were not supported by any objective evidence, and his manner in the witness box, evasive, giving long-winded answers in an attempt to avoid addressing the actual questions posed to him, further undermined his credibility. For all these reasons, it is respectfully submitted that the tribunal should find the respondent's evidence unreliable, self-serving, and inconsistent with the objective facts before this tribunal. If we look at the alleged incident of the 14th of November 2022, an incident which lies at the very heart of this case and is central to understanding both the severity of the misconduct and the complainant's eventual decision to formally lodge a complaint. According to the complainant's evidence, the respondent in his chambers pointed towards his private parts and remarked, "Do you see the effect you have on me?" He then followed that up with the question, "Do you want to suck it?" This incident came after a period during which there had been a noticeable pause in sexually inappropriate messages from the respondent. That pause is important because it could reasonably have led the complainant to believe that the inappropriate conduct had ceased. Yet, this unexpected sudden escalation forms a context for the complainant's reaction, making her response all the more credible. In her own words, this interaction was the catalyst that finally prompted her to lodge a formal complaint of sexual harassment. It is further submitted that the complainant had any intention of that if the complainant had any intention of fabricating this allegation, she could have easily exaggerated the conduct, made it more physically invasive, or added sensational details. She did none of that. She reported exactly what occurred, specific, crude, and uncomfortable, yet contained. This aligns with patterns of misconduct in contexts where there is a stark imbalance of power, as is the case here, where the alleged perpetrator held authority over the complainant. There is no evidence before this tribunal that the complainant fabricated the incident. Her reaction, her evident distress, her communications with colleagues, and the eventual formal complaint all support the reasonable inference that she was responding to real traumatic events. The expert witness, Ms. Lisa Vetten, confirmed that delayed reporting, ongoing interactions, or even superficially cordial messages are entirely consistent with how victims behave in such circumstances. The fact that no third party witnessed the incident is neither surprising nor exculpatory. Misconduct of this nature often occurs in private. The complainant's account was clear, consistent, and critically fits within the broader pattern of the respondent's sexually charged WhatsApp communications and progressive boundary violations, as analyzed by Dr. Docrat and contextualized by Ms. Vetten. In these circumstances, it is submitted that the probability leans heavily in favor of the incident having occurred, as described by the complainant. Her account is credible, untainted by fabrication, and consistent with the respondent's documented behavior. If we now look at the initial complaint, the complainant filed her complaint without legal assistance, attaching screenshots of WhatsApp exchanges with the Judge President. Not all of her responses were included, and the defense has attempted to use these omissions to question her credibility. Yet, as she explained, the complaint was never intended as a verbatim transcript, but as a good faith account of what she experienced as sexual harassment. All the messages before this tribunal were retrieved from her phone, unaltered and intact. By contrast, no relevant messages could be recovered from the respondent's device, as they had been deleted and overwritten. The inference is clear. The complainant preserved the evidence. The respondent did not. Her polite or diplomatic replies must be viewed in the context of a profound power imbalance and employee attempting to manage an unsafe situation with caution, not consent. The incomplete initial complaint, when now read together with a full forensic record, only strengthens her credibility and confirms a consistent pattern of persistent, unwanted, and inappropriate conduct by the respondent. The respondent seeks refuge in technicality that the Code of Judicial Conduct does not expressly mention sexual harassment, and that workplace sexual harassment codes do not apply to judges as they are not employees. With respect, this argument misconceives both the nature and purpose of the Code and the constitutional standard of judicial conduct. Section 14(4) of the JSC Act provides two bases for misconduct. A willful or grossly negligent breach of the Code, or B, any other willful or grossly negligent conduct incompatible with or unbecoming the holding of judicial office. Even if the term sexual harassment does not appear in the Code, the second ground expressly captures conduct that erodes the dignity, integrity, and propriety expected of a judicial officer. Sexual harassment strikes at the heart of those values. Articles 4 and 5 of the Code require judges to act honorably, uphold dignity, and avoid using their office to advance private interests. Sexual harassment and abuse of power and trust is manifestly incompatible with judicial office. Its absence as a label in the Code cannot sanitize dishonorable conduct. The respondent's argument that there is no residual misconduct complaint outside sexual harassment misrepresents both the complaint and this tribunal's mandate. Section 14(4)(b) explicitly empowers the tribunal to consider any willful or grossly negligent conduct unbecoming of judicial office, a provision meant to prevent exactly the type of narrow technical defense raised here. This case is not about morality or private life. It is about judicial integrity. The damage to the judiciary arises from the respondent's own conduct, not the complainant's disclosure. His conditional apology confirms as much, a belated recognition that his behavior was inappropriate. Even if the tribunal were to find that strict elements of sexual harassment are not proved, the respondent's conduct remains gross misconduct under Section 14(4)(b), willful, dishonorable behavior incompatible with judicial office. The respondent's reliance on the non-retrospectivity of the 2025 Judicial Sexual Harassment Policy is equally misplaced. While prospective in effect, it codifies long-standing principles that sexual advances by a judge toward a subordinate are inherently coercive and incompatible with judicial dignity. The policy is persuasive evidence of enduring ethical standards. The respondents further attempt to rely on cultural justification, ukumutsa, must also fail. Cultural interpretation cannot sanitize objectively inappropriate behavior. The concept was never put to the complainant and was introduced late as a post facto rationalization. A judge president cannot reasonably claim to have misinterpreted emojis as consent. Similarly, his appeal to freedom of association misconceives the nature of the judicial office. Judges accept limitations on personal freedom to preserve public confidence. This case is not about prohibiting relationships. It's about power, propriety, and respect. No amount of cultural or constitutional reframing can transform this pattern of conduct. Persistent, unwanted, sexualized communication with a subordinate into anything other than misconduct. I now turn to the legal and ethical framework within which the tribunal must assess the respondent's conduct. The actions of the Judge President are not evaluated in isolation. They must be measured against binding legislation, workplace codes, and the Code of Judicial Conduct, a framework that clearly establishes what constitutes sexual harassment, workplace misconduct, and judicial impropriety. The Protection from Harassment Act defines sexual harassment as any unwelcome conduct of a sexual nature that causes harm. Critically, harm may be psychological or emotional, and a single incident can suffice. Similarly, Section 6.3 of the Employment Equity Act affirms that harassment can arise from a single event. The law recognizes that consent is invalid where it is obtained under coercion, intimidation, or an imbalance of power, a circumstance inherent in a judge president's interactions with a junior administrative employee. The Code of Good Practice on Prevention and Elimination of Harassment in the Workplace provides further clarity. It confirms that sexual harassment includes non-verbal or suggestive conduct, including digital messages, emojis, and gestures. It acknowledges that victims may respond passively, ambiguously, or politely when under pressure or fear of retaliation. The Code also imposes a clear duty on superiors to respect boundaries once discomfort is signaled. Even prior friendly or flirtatious exchanges do not validate ongoing unwelcome conduct. The Code of Judicial Conduct places judges at the highest ethical standard. Judges must act honorably at all times, respect the dignity of others, and avoid exploitative, sexist, or humiliating conduct. A willful or grossly negligent breach amounts to misconduct, particularly when it undermines public confidence in the judiciary. As a Labour Appeal Court noted in Gaga versus Anglo Platinum and others, the fact that a subordinate may initially appear flattered or ambivalent is no excuse, especially where discomfort has been signaled. That is precisely what occurred in this matter. Under Sections 14.4b and 14.4e of the Judicial Service Commission Act, a finding of willful or grossly negligent misconduct is required to sustain a complaint of gross judicial misconduct. It is respectfully submitted that this threshold is met here. What may superficially appear to be consensual behavior is in fact the product of fear, intimidation, or pressure arising from a severe power imbalance. Persistence in inappropriate conduct, despite signals of discomfort, is a hallmark of sexual harassment. The standard is clear on a balance of probabilities. The conduct must be assessed objectively. Here the evidence shows that the respondent's behavior was unwelcome. It was repeated, it was harmful, and it created an unsafe working environment. The respondent's own admission that he may have been...
Sorry to interrupt. You say the test must be what? Subjective? Go back.
It's the standard is clear on a balance of probabilities. This conduct must be assessed objectively. The respondent's own admission that he may have been mistaken and his apology reveal awareness of the impropriety of his conduct, a concession that is in itself telling. A reasonable member of the public would find it wholly unacceptable for the head of a High Court division to persist in sexual advances toward a junior employee, particularly after rebuff and clear discomfort. It is also worth noting the sexual harassment policy of the South African judiciary, introduced in August 2025. While it is prospective in application, it underscores the judiciary's recognition of the risks inherent in power imbalance relationships. It establishes that even subtle signals, avoidance, ambiguity, or non-verbal cues suffice to indicate unwelcome conduct. Importantly, prior consent does not validate ongoing harassment. This policy aligns directly with the complainant's evidence and the expert testimony, highlighting that the respondent's conduct remained unwelcome regardless of any prior interactions. In conclusion, this tribunal is tasked with deciding whether the Judge President's conduct constitutes gross misconduct on a balance of probabilities. The evidence shows persistent, unsolicited, sexualized, and inappropriate communication, corroborated by expert analysis and by the respondent's own admissions. The complainant testified consistently showing courage in reporting a senior figure despite fear of retaliation. Public trust in the judiciary is imperiled when its leaders engage in conduct that would be unacceptable in any professional setting. Viewed cumulatively, the probabilities favor the complainant's account. Her testimony was corroborated, consistent with known victim behavior, and given without embellishment. The respondent's conduct was inappropriate, non-consensual, and constitutes sexual harassment under both the Code of Judicial Conduct and broader legal standards. It is therefore respectfully submitted that this tribunal should find that the respondent is guilty of gross misconduct in the form of sexual harassment. Thank you.
It does not seem as if, it seems as if we've got other heads there as well, from the ones that we have.
It's just a narrative that I drafted for myself. It's not heads of argument, but if you want me, I can draft it in.
I think it will be helpful if you can just put it in the way of heads as well, because your heads are very short in here, and there you gave us a much larger picture of what the matter is all about.
I will do so.
So the test is objective.
Indeed, Chair.
If you read the messages, the WhatsApp messages, if upon objective reading, they don't convey a message of unwanted messages, what then?
Yes, it is indeed so that in the majority of the WhatsApp messages, she did not rebuff him in the words itself. That is the reason why we had to call Ms. Lisa Vetten to explain that. But if we look
Sorry,
at the...
don't go there now, because you can't call somebody to come and interpret the message of somebody else. Abrix Kakane asked her, are you a trained psychologist to come and read people's minds? She said, no. So don't go there. Don't go there. Let's
yes.
go to my question.
But if we look at...
Can I just pose that question? If the test is a reasonable man, if you look at some of the messages that she herself wrote, to a reasonable man, they don't convey unwanted response. What then? Because the test is objective. It's not Dr. Vettel's subjective interpretation.
No, it is true. But if we look at her messages, she does not answer him clearly. She tries to avoid the conversation, and she came and explained that. She did not know how to answer him. But
right,
if we look at the 20th of June...
Thank you to interrupt, because you're not answering my question. I don't want us to argue. I said to you, what if objectively reading the messages that don't convey unwanted participation? What then?
Then we must look at this 20th of June, where she specifically said no, and she even quoted a Bible verse. So there is instances in her messages where she came out to say no.
Where there isn't?
Then the court must decide what is in front of,
Yes.
not the court, the tribunal must
Yes.
decide what is
And
in
by
front.
the way, you speak of the 20, you talk about in East London.
That conversation, yes.
Yes, but the respondent agrees. In that context, there was a rejection because the respondent asked the question, if we meet there at your place, and the danger being that we may melt, shall we end up with being intimate? She said no. And the respondent accepts that there was a rejection with regard to the suggestion of being intimate, but not to flirtation. Let's distinguish that. But anyway, I just wanted to ask you that, because you see, the real question here is whether, upon reading the messages, which we are going to read, the real question will be whether the messages objectively reading them objectively, what do they convey? That's what's going to happen, isn't it?
That is correct.
And if we find that they were unwanted, well, they were unwanted. If we find that they were wanted, or some of them were a mixture, we shall so find. But we are going to read the messages ourselves.
But
I
that
just
is
want
why
to-
it is important to note that even a single incident constitutes sexual harassment. So where she said no and he continued after that, that constitutes
Yes.
sexual harassment.
You said she never initiated.
Initiated sexualized messages.
Yes, thanks. You
Yes.
said so.
Yes.
Is that correct?
She never initiated it.
All right, okay. If we find that she did initiate,
Then I am mistaken, but according to my reading of the messages, I could not find that she initiated the sexual conversations. She might have answered to it, but she never initiated it.
you referred extensively to the incident of the 14th.
Yes?
Is it the 14th or the 15th?
That is still not clear.
Is
According
that
to
not
the
part of the problem? That up to now it's not clear?
that is a problem, Chair.
And there's something that I want to ask you about that, because you talked about it quite a lot. I noticed that there is an argument by respondents' attorneys that with regard to the 14th, when the complainant said she left the court in the afternoon at a certain time, they asked you, sorry, you remember the complainant, the respondent asked for and produced, after this allegation came up, a recording of the movements of his vehicles on the 15th, which showed that he left the court around the 15th to some other place. I noticed that the respondents' lawyers say that because the complainant says that she left at a certain time on the 14th, and they say no, she left earlier than the JP secretary. I noticed that they asked you to produce a record showing the movements of a vehicle, apparently it's a government vehicle. They say that they asked you to produce a record of the movements of a vehicle on the 14th. Do you recall that?
I recall that.
Why was that not done?
At that stage, it was not known that they are talking about the fact that the complainant left, the leaving of the premises from the complainant and the judge's secretary, that there was a discrepancy. The laptop register was only provided later. It was never in dispute that the complainant was there. It was never in dispute that the Judge President was there.
But there's a dispute as to when she left. The
But that-
dispute is, let's not fudge issues.
Yes?
The dispute is, the respondent says the complainant left before the JP secretary. The complainant had said the judge's secretary had left earlier. But the respondent says, no, the person who left earlier is the complainant and not the judge's secretary. And then they produced a record, security register, which shows that the complainant left earlier and the JP secretary later. That is the dispute. And then they said, to confirm the fact that the complainant left earlier, please produce the records of the movement of her vehicle.
No, that was not what was requested. At the
Oh.
stage when it was requested for the tracking record, it was not known that the judge's secretary left after the complainant. That was not known to me at that stage.
Anyway, if I'm wrong about that, they will speak for themselves, because that's what I thought. And, okay. I think those are the clarifications I sought.
Thank you, Chair.
Advocate Scheepers, just one question for you, please. In the event you are to find that the conversations or the exchange of email, of WhatsApp messages between the complainant and the JP were consensual, would that still sustain the charge of sexual harassment then?
No, because then it's not unwelcome. If it's consensual, then the unwelcome part falls away.
Then what about then the element of gross misconduct then?
If there's no sexual harassment, there cannot be gross misconduct.
Okay, thank you. Thank you.
Sorry, there's something you referred to lack of credibility on the part of the respondent in your submission, and you are entitled to do that. Are there no aspects in the complainant's evidence which raise issues of credibility? If there are, you haven't mentioned them.
I think there is definitely aspects of credibility issues on the complainant's testimony. She could not give answers, especially when she was cross-examined on the two different statements that were exactly the same. So there are definitely some credibility issues in the complainant's evidence as well, but we must also look at what the objective facts, the WhatsApp messages that we have in front of us. That is what we have to deal with as well.
Does it not worry you that the complainant, and this came through questions by Advocate Butland, does it not worry you that the complainant sought to cast Ms. Moretwe as lying when she said, Ms. Moretwe said, I left at 9 o'clock because it was getting late. The complainant said no. And we know why she said that, because she was insisting about the fact that she didn't have a copy of the other statement. The complainant says, no, Ms. Moretwe didn't leave at 9 o'clock. She left at 12 o'clock, midnight. She left after 12 o'clock midnight. It's a concerning aspect, because when Ms. Moretwe says she left at 9 o'clock because it was getting late, all of us knowing how dangerous it is in this country for a young woman, and she says, and then somebody says she left after 12 o'clock, and which, well, I don't know whether she would have felt safe to leave at 12 o'clock, but it's improbable. Does it not bother you that, with reference to those two statements, does it not bother you that complainant went so far as to cast Ms. Moretwe as lying when she says she left at 9, and conveniently, seemingly pushes her stay to 12 o'clock to accommodate the previous lie? Does it not bother you?
It is not good for the complainant's case, yes.
Yes. Advocate Butland.
Thank you, Chairperson. Chairperson, the questions that you've just asked my colleague, the evidence leader, I will respond to as well, since they are clearly questions that concern the panel, but I'll do so towards the end of my address, with your permission. Chairperson, members of the tribunal, let me start by thanking the tribunal for permitting us to file written submissions and also to address you today. These proceedings have run on and off since January this year, and they have not been easy for anyone involved. we've said repeatedly, and we've been criticized for doing so, that these proceedings are unprecedented. But they are indisputably so. And it's not because sexual harassment is not common. We know that it is incredibly common. But it's because this is the first time that a sitting judge has had a complaint referred to a Judicial Conduct Tribunal on the basis that the complaint establishes a prima facie case, which, if substantiated, is likely to result in a finding of gross misconduct. How this tribunal deals with this complaint will set the standard to which we hold our judiciary, will send a message to the public at large about what we consider to be appropriate behavior from a judge and what is not appropriate. This case raises complex issues, but the question that sits before this tribunal is not complex. It is contained in the terms of reference, which provide, and I quote, "The allegation is whether or not, as a result of the conduct referred to in Ms. Mengo's complaint, Judge President Mbenenge is guilty of gross misconduct in terms of Section 177 of the Constitution." And I'll come in the course of my submissions to an analysis of Section 177 and of the meaning of gross misconduct. But for purposes of this introduction, let me say this: we will submit that the conduct which Judge President Mbenenge himself admits to, let alone what he disputes, that it in itself amounts to sexual harassment, and that it is conduct which we will contend constitutes gross misconduct as envisaged in Section 177(1)(a) of the Constitution and Section 14 of the Judicial Service Commission Act. We know that sexual harassment is prevalent in our society. We know that. We've quoted statistics in our heads of argument. Our heads of argument refer to a report by Judges Matter, which reference the fact that sexual harassment in the South African legal profession is more prevalent than the global average, and that 43% of women in the legal profession have reported experiencing sexual harassment, and that 25% considered leaving or have left the profession. And that you'll find at page 41 of our heads. So this complaint is important. It is only about Ms. Mengo and Judge President Mbenenge, but it also is not. How this tribunal assesses the evidence and the conduct of the Judge President will likely determine whether other women with legitimate claims come forward with their cases. Now, clearly, this tribunal has to make its decision based on this case.
Sorry, I don't understand that point.
Well, if
You can't say how we do it will determine. Each case is adjudicated according to its own facts. We are going to determine this case, as I said at the beginning, according to the law and according to the facts before us. As what the outcome thereof is, we don't know.
Chairperson, as I was saying, it's clear that this tribunal will make its decision based on this case and these facts. But the import of this ruling will have an impact on how issues of sexual harassment are dealt with in the future. Now, it's not to say that that must sway your decision, because you must apply the facts. But we cannot pretend that when we make findings about how women are required to behave and how that behavior translates into whether or not there is perceived consent, for example, that will not have an effect on other women and whether they choose to come forward with complaints. That is the extent of my submission. This case is important, and we cannot pretend that it's just about these two people. It is not. Now, I have noted that the tribunal has, thank you very much, read our submissions very carefully and considered them, and I will certainly try and keep my submissions short and focused on key issues and themes. I've also noted, listening now to the evidence leader's submissions, that there are things that she has dealt with that I will try not to repeat. But I would ask the tribunal to bear with me because I've only just heard those submissions. I intend in my submissions to deal with the following issues. First, I'll provide a very brief overview of the complaint and the respondent's version. Then I will deal with the standards that we expect of judicial officers and how they apply to the respondent. Third, I'll deal with the correct definition of sexual harassment and its implication for the evaluation of evidence in these proceedings. And then fourth, I will respond to some of the arguments raised in support of the respondent through the course of these proceedings, but pertinently in the heads of argument of the respondent. So to start with a brief summary of the case to contextualize my submissions. The versions of the complainant and of the respondent are summarized in our heads from pages 29 to 47. I'm not going to repeat them. What's relevant is that we have evidence from the complainant who testified over the course of 10 days. 4 of those days were under cross-examination. We will submit that she was consistent, that she was open, and that she was honest with this panel. There may have been things where she did not have an answer, but she did not shy away from that. There may have been answers that we don't like, but she didn't shy away from that. She brought evidence to this panel that did not all portray her in a good light, but she brought all evidence that she had to this panel. So we ask that her evidence is considered in that context, and I'll respond in due course to the chairperson's questions around her credibility. Now, the complainant testified that she did not want to engage in either a romantic relationship or in sexual conversations with the Judge President, but that she felt compelled to respond to his messages because of their relative positions. She testified that the conduct was unwanted, that it was persistent, that it was of a sexual nature. She also testified that she said no on many occasions, and we counted these through the transcript. There are approximately 13 occasions on which the complainant said no, either specifically using the word no, or using words such as, "It is impossible," when asked whether she would melt by the Judge President. When she told him, you must control yourself. And various other instances, quoting the Bible verses where the first word, hai, means no. So in different ways, this complainant, if you look at the WhatsApp, said no many times during the course of this, 13 that we can count. She testified that she did not see the respondent as a romantic partner, but she saw him as an elder, a leader in the court, and at times a father figure. She testified that she was shocked by his advances, and she was confused about what to do. In response, the respondent's defense can be summarized as follows. A respondent admits to having initiated WhatsApp conversations with the complainant. He admits that they were clearly of a sexual nature. He admits to having persisted in requesting sexual photos of herself, or rather naked photos of herself. He admits a request for them to be intimate. However, he says he was merely engaging in a consensual relationship, that this was a cultural practice, and that his attention advances were welcomed by the complainant. And overall, he says that it was objectively reasonable for him to assume consent in light of their conversations. So in short, he says these conversations were welcome, and there was no way in which he could reasonably have been expected to know that they were not. Well, we will argue that it's not just factually incorrect, but that any reasonable person in the position of the Judge President would have realized that his conduct was not just inappropriate, but it was unwanted, and it was in conflict with his obligations as a judicial officer. On the Judge President's own version, he admitted to having badgered her and persisted in his attempts to get her to send him photographs to engage in sexual conversations, and to be intimate with him. In fact, in support of this, he testified that this was part of a cultural practice which permitted him to refuse to accept a no from her, from a woman that he was courting, because she couldn't have meant no in this ritual. Now, that was never put to Ms. Mengo, and I'll come back to that. Now, the logical conclusion of this argument, if it's held to be valid, is that it is permissible to persist and to badger a woman to engage in sexual banter with you, to send you photographs of herself, to be intimate with you, until she eventually gives in and engages. That's the logical conclusion of that argument, because it's clear to her that she has to engage at some point because you're not going to accept a no. So even if she engages because she wants you to leave her alone, that will be taken as consent on your part. That's the logical conclusion of that argument, which we say must not be held to be valid. In fact, we say that is the very definition of sexual harassment. It's unwanted sexual attention of a sexual conduct that is often persistent. It doesn't have to be persistent, but often it is. So while we go through the evidence and while I make these submissions, I'll ask this tribunal to ask itself whether the conduct that the Judge President himself admits to having done, just those, what he admits to having done, whether those conversations that he admits to having with a junior secretary in his division in circumstances where he's a leader of that judiciary is conduct that this tribunal considers to be in line with the Judicial Code of Conduct and in line with the standard that we expect of our judiciary. Because what is at issue here is his conduct. It's not her conduct. It does not matter whether you like the complainant. It does not matter whether you think that the way she chose to respond to his persistent badgering for sexual attention was how a perfect victim should respond. What matters in these proceedings is whether the Judge President's conduct meets the requisite standards of a judge. And we submit that it does not, that his conduct evinces a clear indication of sexual harassment, that it amounts to gross misconduct in terms of Section 177 of the Constitution. More than that, we submit that his conduct was so blatant and abusive that it has eroded confidence in the judiciary and that it has brought the institution into disrepute in the eyes of ordinary South Africans who watch these proceedings. The conduct to which the Judge President admits, if it happened in any other workplace in South Africa, would, I submit, constitute gross misconduct and would be a dismissible offense. And in the judiciary, where we are told to hold our judges to a higher standard, there can and there should be, we submit, no conclusion short of this. So that brings me to the question that this tribunal has to engage with, which is, what is misconduct? Now, the starting point of what this tribunal has to consider is gross misconduct in 177 of the Constitution. But what do we do where the Constitution doesn't specify what types of instances, what types of conduct will amount to gross misconduct? Well, in Hlophe versus the Judicial Service Commission and others, that's cited in our heads of argument, but the reference is 2022 3 All SA 87, it's a Gauteng division. The court looked at what is gross misconduct and how it is to be determined. And they said the starting point is the Constitution. They said Section 177 of the Constitution provides that a judge may be removed from office only if the JSC finds that the judge suffers from an incapacity, is grossly incompetent, or is guilty of gross misconduct. And the court went through analysis and held that it was not helpful to consider the concept of gross misconduct in the context of, for example, labor law, which was one of the arguments raised. But that instead, and I quote, what constitutes gross misconduct must be understood in the context of the whole of Section 177 1A. When the other two expressly mentioned grounds for removal are taken into account, it seems incontrovertible that what is contemplated is conduct that renders the judge unfit for a judicial role. And that you'll find at paragraph 116 of the Hlophe judgment. So it's conduct that renders the judge unfit for a judicial role. The court also held, and I quote, that the tool of a threshold of misconduct, which intrinsically requires a hierarchy of sin, is mechanical. As such, it is dysfunctional to the purpose of section 177(1)(a). What is required, the court said, is a fact-specific inquiry in the round into all the relevant events upon which foundation of finding of fact can be made, which is then subjected to a qualitative assessment as to whether a person who behaved in the proven manner is fit for purpose in a judicial role. So we will submit that if one is to apply, as the court says we must, a qualitative assessment of the evidence before this tribunal, we would submit that the Judge President is guilty of sexual harassment and that his conduct rendered him unfit for a judicial role. And that then constitutes gross misconduct as contemplated in 177 of the Constitution. Now, one cannot simply consider this without looking at what are the appropriate standards for judicial conduct, which also find their way into a determination of whether or not there's been gross misconduct. The respondent disagrees with us on this. They argue that the Judicial Code of Conduct finds no application in these proceedings. And somewhat curiously, they base this on the fact that the Judge President, they say, has not been charged with dishonorable conduct. And if he's not charged with dishonorable conduct, then one doesn't have to have regard to the code. Now, we respectfully submit that that's incorrect as a matter of law, that it misses the point and ignores the provisions of the Judicial Services Act. First of all, Section 12 sub 5 of the Judicial Services Act provides that the code shall serve as a prevailing standard of judicial conduct, which judges must adhere to. And then the code itself, in item 10 of its preamble, specifically states, Section 12.5, read with 14.4b of the Act, that's the Judicial Services Act, Commission Act, specifically provides that the Code of Judicial Conduct shall serve as a prevailing standard of judicial conduct, which judges must adhere to, and that any willful or grossly negligent breach of the code may amount to misconduct, which will lead to disciplinary action. So what we see here is a link, a very clear link, between the Code of Judicial Conduct and the Judicial Services Act. Both those things guide this tribunal, and I would submit that to make a finding of misconduct or lack of misconduct without looking at the Judicial Code of Conduct, it would be wrong to do so. Now, there are only, if one looks at the Act, there are only a limited number of grounds on which a complaint can be made against a judge. Those are in Section 14.4 of the Act. The complainant, in bringing her complaint, you heard from the evidence leader, she was not legally advised at that time. She did not identify any particular section of the Judicial Services Commission Act as the basis for her complaint. But Section 14.4 of the JSC Act specifies the grounds on which a complaint can be made, and we submit 3 of them may be relevant to this tribunal. Those are in Sections 14A, B, and E. 14A lists one of the first ground on which you can lay a complaint against a judge as being incapacity, giving rise to a judge's inability to perform the functions of judicial office in accordance with prevailing standards, or gross incompetence, or gross misconduct, as envisaged in Section 177(1)(a) of the Constitution. So gross misconduct is referred to in 14A. 14B deals with any willful or grossly negligent breach of the Code of Judicial Conduct. And 14E refers to any other willful or grossly negligent conduct other than conduct contemplated in paragraphs A to D above, that is incompatible with or unbecoming the holder of judicial office, including any conduct that is prejudicial to the independence, impartiality, dignity, accessibility, efficiency, or effectiveness of the courts.
Sorry, those then will be a misconduct other than gross misconduct.
Yes, it's an unusual framing in the Act. Gross misconduct is referred to in paragraph A. So but paragraph A actually includes both incapacity, gross incompetence, and misconduct, which reflects the Constitution, basically. Those are the three main grounds on which you can impeach a judge. And then
My suspicion is that at some point we may have to focus on that except blah, blah, blah. We may have to, the category of conduct as opposed to category of gross misconduct. We may have to look at that more closely.
Yes. Chair, you raise an important point, because actually when one reads the respondent submissions, I may be misunderstanding the argument, but there is a fair amount of emphasis placed on what was reasonable, what a reasonable person in the position of the judge could have been expected to do, and that then triggers questions around gross negligence rather than purely misconduct. I would submit that that when one looks at all of that, these are grounds on which you can lay a complaint. Ultimately, the finding will be one of gross misconduct, because that links with Section 177 of the Constitution. But we can engage with that further if the panel would like to. Now, when one looks at the code, I don't want to, the evidence leader went into some measure of detail on some of the provisions of the code, so I'm trying not to repeat that. But it's important to note that the aim of the code is to, quote, assist every judge in dealing with ethical and professional issues, and to inform the public about the judicial ethos of the Republic. So that is the purpose of the code. And one would imagine that when a judge is in a position that he or she thinks that they need to evaluate their conduct or to question how to behave in a particular situation, that this code of conduct would guide and assist that judge. In fact, it says so. It's to assist every judge in dealing with ethical and professional issues. So it's important to look at this code in a case such as this. I've already mentioned that the Code of Conduct serves as a prevailing standard for judicial conduct, which judges must adhere to. It also incorporates the Bangalore Principles, which are the internationally acceptable principles that South Africa has signed on to. And so there's an international aspect to the standards that we apply to judges. And one sees this where we refer to a case from the Ninth Circuit of the U.S. Court of Appeals, which didn't obviously refer to our code, but referred to their code, and that some of the language was very, very similar. This is because these are international standards that judges are held to in the countries that have signed on to the Bangalore Principles. Now, Article 5 of the code was referred to by the evidence leader. Article 5 deals with the obligation to act honorably. Importantly, it provides that a judge must always, not only in the discharge of his official duties, so he must always act honorably and in a manner befitting judicial officers. There's an explanatory note to each article, as the panel will be aware, and the explanatory note to Article 5 explains that a judge behaves in his or her professional and private life in a manner that enhances public trust in or respect for the judiciary and the judicial system. So, and then it says a judge avoids impropriety and the appearance of impropriety in all the judge's activities. And then note 5 sub 4 says judicial conduct is to be assessed objectively through the eyes of a reasonable person. So that is in line with the question asked of the evidence leader. The conduct must be evaluated objectively, must be assessed objectively. In our heads, we refer to 3 cases in support of this. We refer to the Motata case, the Hlophe case, and the US case that I've just referred to, the Kindred case. I'm not going to go into detail into those cases. They are dealt with extensively in our heads of argument. But suffice it to say this, that each of those cases, particularly Motata, emphasized the importance of public perception, and that links with the idea of what a reasonable person how a reasonable person would assess the conduct in question. The respondents in their heads of argument suggest that the Mutata case is not relevant because in that case, Judge Mutata had already been convicted of a crime. But in fact, that misses the purpose for which we are citing this judgment. The respondents suggest that we are premature in relying on that because there's no conviction here. But that's not what we rely on it for. We rely on it because in Mutata, the SCA quoted the Supreme Court of Canada in relation to the standard expected of judges in general. And I quote, "Public confidence in and respect for the judiciary are essential to an effective judicial system and ultimately to democracy and founded on the rule of law." And the SCA in that case specifically explained that there is a link between the perception that a reasonable person holds of the judiciary and the effective administration of justice. And we quoted in our...
Sorry, but that picture is founded on the fact that Mutata was convicted.
No, it's not. If one reads the judgment, it is about his conduct as a whole. So it's not just about the conviction. It looks at the conduct of Judge Mutata in how he responded, the racist comments that he made when he was on the scene, and his behavior as a whole. And so this, what the Supreme Court of Appeal says about the perceptions of the Republic is about how we view judges' conduct. It's not about how we view judges' conduct once they've been found guilty of something. It's in general. And in fact, they say at paragraph 81 of the judgment that the Judicial Service Commission has been charged by the Constitution and the Judicial Services Commission Act to inter alia protect the integrity of the judicial system. In discharging that function, it had to be sensitive to the expectations of a reasonably well-informed and dispassionate public, that holders of judicial office would at all times remain worthy of trust, confidence, and respect, at all times. So, in our heads, you'll see that the SCA quoted Lord Phillips in a case from the Supreme Court of Canada, again, talking about the standards required of judges, the public perception of that, and the fact that the public requires, whether we like it or not, virtually irreproachable conduct from anyone performing a judicial function. And that the standards require is the appearance of that conduct, as well as the conduct itself. Chair, I see that it's 1 o'clock. I'm not sure if you'd like me to continue. I still have a fair amount to get through.
I think continue, where we'll have to stop maybe at 1:30.
Sure.
I think they will have to, the Secretariat will have to confirm with us whether we can go for lunch at 1:30. Yes, you can proceed in the meantime.
Okay. Then in line with this objective standard that the SCA in Mutata referred to, our heads also deal with Hlophe judgment, which also talks about the importance for a judge to remain visibly and manifestly imbued with integrity and act with good judgment. And of course, as I referred to the US case. We submit that in Judge President Mbenenge's case, there is no circumstance under which it was appropriate conduct for him as a leader in the judiciary to engage in the manner that he did with Ms. Mengo. Now, I say in the manner that he did because there was a suggestion that there's nothing wrong with a judge having a relationship with the secretary per se. That, in fact, we were told that some judges have married secretaries. That misunderstands our argument. It's not to say that we don't think that there are instances in which there can be consensual, permissible relationships. There is no bar on relationships within the court system. What we're saying is that the manner in which this took place was inappropriate. Now, if the Judge President had genuinely wanted to engage in a open relationship with Ms. Mengo that everyone in the court was aware of. There was no secret about it. There's nothing wrong with that. There's nothing wrong with dating a secretary. But this, and what one sees from the WhatsApps is, and even from the respondent's testimony, is that's not what it was. This was about wanting to engage with her on sexual content only. This was wanting to be intimate with her without having a formal relationship. And Ms. Mengo said in her evidence that that is why she said to him, come out clear. Come out clear. Because her understanding of someone who wanted to have a relationship with you was that they would, in her language, propose. Now, that's not a proposal of marriage, but it is to propose a formal relationship. I would like to date you, for example. But she said in her testimony, and we can find the reference if necessary, that that was not what she received from the Judge President. What she received instead from day one was a request for pictures of herself, where she removed the top part of her clothing, kulula mutla. So this whole case may have been very different if a different relationship, if there was an intention to have a different kind of a relationship, and if that was conveyed clearly to Ms. Mengo, and if she was given a proper opportunity to say no, and where she said no, that was respected. That is not what this case is about, at all. And what we've seen from the Code of Conduct is that there is a standard required of judges, at a minimum, I would suggest, to make sure that when you're engaging with someone, you do so in line with that Code of Conduct. In your public life, in your private life, that's what the Code says. You are always a judge. You are never not a judge, and you are never not required to comply with those standards, as high as they are. So, with those standards in mind, I'd like to turn to the definition of sexual harassment. It's important to start by understanding what is sexual harassment and how this tribunal must seek to identify whether the conduct before you constitutes sexual harassment. And some of the questions from the panel, some of the evidence from the tribunal have suggested that a rather simplistic understanding of what is or what isn't sexual harassment. And the evidence of the experts was an attempt to show that it is not that simplistic. But I'll come back to that. Let's start with the definition. The respondents asked this tribunal to use the definition of sexual harassment in the Equality Act. And they say in their heads of argument that you'll find the definition of sexual harassment in section 1.1 of the Act. But you won't find a definition of sexual harassment in 1.1 of the Act. What you'll find is a definition of harassment on various bases. One of them is on sex and gender. That is different, we submit, to a definition of sexual harassment. And that's why we don't use the Equality Act, we use the Employment Equity Act. What's one of the reasons? The Employment Equity Act itself addresses sexual harassment directly, squarely. It provides detailed understanding of what sexual harassment is, what processes must be used to determine sexual harassment, and provides a court, or in this case, if this tribunal considers it, this tribunal, with guidelines about how to deal with sexual harassment. So the Equality Act, we would submit, is not the right framework to use for understanding sexual harassment. The correct framework is to be found in the codes of good practice on the prevention and elimination of harassment in the workplace. Those are issued under the Employment Equity Act. But the most important indication that this is correct is that the Equality Act itself, in section 5.2, states that this act does not apply to a person to whom and to the extent to which the Employment Equity Act applies. So if the Employment Equity Act applies, as it does to Ms. Mengo because she's an employee, then you don't look at the Equality Act. You look at the Employment Equity Act. And if one was to have taken this to the Equality Court, for example, that would have been an argument raised about the correct jurisdiction of that, whether that court had jurisdiction. So the Employment Equity Act self-evidently applies to her. It is because she's an employee and that this conduct took place in the context of her workplace. and in the context of her work as a judge's secretary. The WhatsApps make it clear that on various occasions, the JP would message her only about work, or that on other occasions he would always start with asking her work-related questions and then move on to the more sexual content. So, and we saw that when he asked about protests near the court, when he asked her what her judge was doing, all of those sorts of things. So this conduct took place in a workplace, and it is irrelevant for purposes of the law whether the Judge President was Ms. Mengo's employer or not. Much was made of the fact that he was not her employer, but he doesn't have to be her employer for purposes of the Employment Equity Act. It is not necessary that he himself is an employee even under the Act. The Act specifically says that it applies to employees, but it also applies to situations in which third parties such as, and they list a series of potential third parties, outside contractors, for example, are accused of sexual harassment of an employee. So the Act squarely applies, and it is irrelevant whether or not Judge President Mbenenge is an employer of Ms. Mengo. His position is relevant to balance of power and to other issues, but not to whether or not the Employment Equity Act applies. The fact that the court system in general is considered a workplace is also made clear from the most recent sexual harassment policy that was issued by the Chief Justice in August 2025. I'm not suggesting that it applies to this case, but it is helpful for this tribunal to look at what the Chief Justice and the Office of the Chief Justice considers to be sexual harassment. And specifically in that policy, it states that the South African judiciary acknowledges that each of its members are in positions of considerable power, authority, and influence in relation to staff in the judicial working environment, members of the legal profession, and the general public. Sexual harassment is an abuse of power, and for this reason, it is the responsibility of every member of the South African judiciary to remain vigilant of how their conduct may be received or perceived by those with whom they do not share the same power, authority, and influence. And the respondents say the policy is not relevant. It is relevant. It's relevant to this extent. It codifies the existing law on sexual harassment. It sets out the standards required of judges' conduct and codifies them. And most importantly, it provides this tribunal with an indication of the manner in which sexual harassment is to be understood going forward and treated in the context of the judiciary. So it would, we submit, be an extraordinary thing for this tribunal to find that the court environment is not a workplace for purposes of this complaint, where the 2025 sexual harassment policy explicitly makes it clear that it is. But as I said, in any event, the 2005 code on prevention of sexual harassment makes it clear that it applies to employees, but also to people that are not employees in their engagement with an employee, and that is dealt with in our heads at paragraph 63. Now, in terms of finding a definition of sexual harassment, there are various codes that are set out in our heads of argument under the Employment Equity Act. In Campbell Scientific, Judge Satch, trying to remember which judge it was, but in the relevant case is Campbell Scientific. I think it was Judge Savage, who indicated that the codes don't supersede each other. So one must effectively read all of those codes together to understand sexual harassment. So we detail the various codes in our heads of argument from page 58, but in short, sexual harassment is defined as unwanted conduct of a sexual nature. The unwanted nature of sexual harassment distinguishes it from behavior that is welcome and mutual. Importantly, the code goes on to say that sexual attention becomes sexual harassment if the behavior is persisted in, so if there's persistence, although a single incident of harassment can constitute sexual harassment. And then, so that's one factor, and or the recipient has made it clear that the behavior is considered offensive, and or the perpetrator should have known that the behavior is regarded as unacceptable. So any one of those three factors would satisfy the definition of sexual harassment. I'll just refer the tribunal to the fact that the 2005 code, which is also set out in our heads, sets out a test for sexual harassment and requires a court taking this into account to consider a series of factors, whether the harassment is on the prohibited grounds of sex or gender, sexual orientation, whether the sexual conduct was unwelcome, the nature and extent of the sexual conduct, and the impact of the sexual conduct on the employee. Those are all relevant factors. The code also sets out different ways in which an employee may indicate that the sexual conduct is unwanted, and that includes verbal conduct, but also non-verbal conduct, such as walking away or not responding to the perpetrator. And again, that code applies broadly to workplaces and the working environment. Okay. Now, if I can then turn to this issue of a power imbalance. A power imbalance is, or an imbalance of power, is a common constituent of sexual harassment. Ms. Vetten testified to that. It's also recognized in the 2005 policy on sexual harassment, policy for the judiciary. Now, the respondent was at pains to contend that he had no power over the complainant, but the complainant contradicted this specifically. In fact, she testified to this power imbalance on several occasions. For example, on the 13th of January 2025, page 25 of the transcript of that date, she said, in response to a question about why she responded to the Judge President's sexual messages, she said, "Here we are talking about a powerful person. We are talking about someone who's in charge of the entire province. It was difficult to say no to him, although I said no, no, no on numerous occasions, but he did not listen to that or hear my no. More than anything, I was scared of how he was going to treat me at work because I do not know what he was going to do to me, and there was no one who was going to believe me if I were to convey my story." So her perception of the respondent's power is also evident in her trying to bring her concerns with the court manager, for example, to his attention. The Judge President had power in that division, and she recognized that he had that power, and that is why it was so difficult for her to deal with how, perhaps in a way that may have made all of this much simpler, it was very difficult for her simply to ignore his messages completely, for example, not respond to them, because at the end of the day, he was the Judge President who was messaging her. Now, the Constitutional Court in McGregor, which is also quoted in our heads, looked very closely at the long history, an accepted history of this notion of a power imbalance and how it operates in the context of sexual harassment. And in the Constitutional Court case of McGregor, it was about a doctor sexually harassing an intern. And in that case, the doctor was not the intern's employer. The Department of Health was the intern's employer. But the Constitutional Court still found that that hierarchical level within the workplace amounted to an imbalance of power. And that imbalance of power was a relevant factor in determining sexual harassment. And this was also confirmed by Dr. Vetten, who talked about what she called unofficial layers of hierarchy in the court system, and the power that a judge president would have to comment informally, for example, if asked about a secretary's performance or if they were any good. So an informal comment, even if he wasn't doing a formal performance review of her, for example, an informal comment to another judge may well have had very serious consequences for her. And the respondents tried to suggest that despite all of that, there was no power imbalance. They say Ms. Mengo is an adult. They say in their heads of argument she's outspoken, she could stand up for herself. They even say that she was set in her ways. But we all here know, we work in a court system. We know that the Judge President is not just some other employee in a court. He is the Judge President. He is the head of court for that whole division. Particularly this Judge President, who we know from his own evidence is well respected in that province. So there's a clear undertone that's worth mentioning, that in the case advanced on behalf of the respondent, there's a clear suggestion that if a woman is on the receiving end of sexual harassment, she must speak up, she must rebuff the perpetrator, and she must move on. And if she doesn't, then she's consenting to this. The argument goes, is whether she stands to lose her job, whether she may be attacked physically, whether her life may be in danger, whether she may be hurt in other ways, whether she will be forced to bear the consequences of saying no. How Ms. Mengo may have responded to some person in the street or in a bar or in a restaurant who said these things to her could never have been the way that she responded to her Judge President. That we must accept as so. Women, Ms. Vetten says, are not always able to say no. They're not always able to say no to a boss, to an elder, to someone who wields power and demands respect. We all witnessed the respondent's testimony. We saw his demeanor.
Just in passing, you say they are not always able to say no. If they don't say no, how will you know they are saying no?
The way you know that someone is saying no is you look at the objective facts, you look at their conduct. Where a Judge President asks someone on the first day that he's engaging with her,
where the objective look does not provide the answer or gives an opposite answer.
In this case, the objective facts show that she said no.
My question is where the objective test does not show a no.
Yes, if objectively you think that there was no rebuff, then sure, then there's no sexual harassment. But we submit in this case, there are so many instances in which she said no. In fact, she said no, I counted 13 times. But this tribunal cannot ignore the evidence of the expert. This tribunal cannot ignore the fact that women do not respond in the same way to every situation. I know this as a woman in the profession. A junior colleague is able to respond very differently to the way that someone in my position can respond. The same is true of Ms. Mengo in a court system. So we witnessed his testimony, the Judge President's testimony. We witnessed his demeanor. We witnessed his cross-examination. This is not someone that's easy to stand up to. It may be easy if you're a judge or if you're a senior counsel. It is not if you're a secretary in that court. So it's imperative that this tribunal appreciate that nothing about how Ms. Mengo chose to react or how she reacted in that situation that she found herself was simple. She told you that in her evidence. She said, these were the things that were concerning me. He was my boss. I was scared of what might happen. She also said that she tried different ways to rebuff him. She said no. She ignored him. She refused to give photographs when asked. She got sarcastic from time to time. And she said, I asked her specifically, why did you engage in sexual banter with him? Why did you respond to his sexual questions? And she said she didn't know what else to do. Nothing that she had tried had worked. And she thought maybe if she engages with him, he'll leave her alone. That was her testimony. Ms. Mengo is not a perfect victim, but there are no perfect victims. There is no rule book for how we are meant to respond when harassed. There is no one way in which a woman responds. And Mr. Vetten confirmed that. And Ms. Vetten's qualifications as an expert on the subject of gender were not disputed. She was cross-examined on her knowledge of culture, but she was not disputed not to be an expert on gender. And this tribunal must take her expert advice, we submit, in that regard. Ms. Mengo was cross-examined for 4 long days. She was on the stand for 10 days. She's a strong woman, and she's resilient. That's true. But strong women are sexually harassed every single day in this country. And to suggest that because she had an opinion and that in the right circumstances she was not afraid to voice it, in the respondents' heads of argument, for example, they say she felt comfortable enough moving the photograph of the Judge President from outside her office. That made her bold. To suggest that because she can do all of those things in those contexts, that means that she could not be sexually harassed in this context. It's an unacceptable contention, with respect. And it's one on which our courts have already opined on, that experts on issues of sexual harassment have long recognized. And it's a dangerous argument, with respect, because it effectively says that only the perfect victim can be harassed. It says a perfect victim must be sufficiently meek and mild. She must also be strong enough to reject any advances outright, even from a superior and with someone who has power over her, and even when her job and livelihood may be at risk. So that victim does not exist. What does exist is the fact, as I've said, women behave differently in different situations, and that's why the objective test is what is relevant. That's why we say you must look at these WhatsApps as a whole. It's very important that one does not take WhatsApps out of context, that one looks at these WhatsApps from start to finish, and that one reads the conversations as a whole. And when one does that, one sees that there is a pattern to the behavior of the respondent. There is a pattern of persistence, there's a pattern of starting off by talking about work and then moving into sexual conversations. There is a pattern of not taking no for an answer. When, on several instances, Ms. Mengo refused to respond, and despite her silence, the respondent responded with the listening ear emoji, or twaka, silence, he said to her, as in, where is your response? So whatever she did, the respondent would not leave her alone. And we submit that when this tribunal looks at her conduct and questions why she responded in particular ways, you must not look at one line. You must look at the whole conversation. And you must see that it is correct that she, and I'll come to this in due course, she never initiated a single sexual conversation, not one. It's there in the WhatsApps. Ms. Vetten confirms it. Dr. Docrat confirms it. Not one instance of sexual conversation was initiated by her. And I'll come back to that in due course. So we submit there's an undeniable, clear power imbalance between the complainant and the respondent, and that the respondent exploited that imbalance to sexually harass the complainant. To suggest otherwise would be to ignore not just the jurisprudence of our highest court, such as McGregor and the Constitutional Court, but the views of the experts on gender. And mostly it would ignore what all of us working in a court environment know to be true. Chairperson, I'm about to move on to a new section. Would it be convenient to take the lunch adjournment now? Okay.
Yes, I'm just wondering, is the food nearby? Maybe we could come back at 2:15. We'll adjourn until 2:15.
last time ngilana ndo basinvite for lunch. Hayi mara yabakhekhe zuna proper futhi spinach futhi rice.
I'm wondering, have people when lost to do? Oh yeah, people.
Is there anything wrong with Julius being friends with Julius? Is there
who's friends with who? We are taking friends, we are taking friendship to court. That's right. We've got more problems.
He's still alive. No, you would not have done that. Did he not die a long time ago? Many years then. That's somewhere there.
Briggs is still in prison.
When? Yes. Not present, but I was arrested. Second time I'm driving. Second of all, man, this one. What that day? It's embarrassing. About that, I got drunk driving. It's too stupid. Stupid, you're like, Mara, what is this? That time, They're not even eating. His argument is eating you. Can't even eat.
You'll be happy to know that we'll finish today because we are going to sit until we finish.
That's fine with us, Chair. No complaints.
Just a matter of, I throw this for just a matter of observation. Because Advocate Butler, you made a statement to say that you counted no less than 13 no's, referring to the highs. I think it should be mentioned in all fairness that during the interpretation, some of the highs that we're referring to were interpreted as exclamations, not as no's.
Yes, no, Chair, I'm happy to put up a list of those no's if it would assist. It does not take into account anything that was disputed to be a no. But if it would assist, I'm happy to do that.
Yeah, you may proceed.
Thank you. Chair, the evidence shows a gradual and persistent escalation of the respondents' demands and conduct. So we went from the 8th June, which was the first WhatsApp exchange between the parties, where you saw the respondent asking simple questions about Ms. Mengo's child, about her appearance, how she keeps fit. And within the first hour of that WhatsApp exchange, he asked her for a photograph of herself, and then proceeded to continue to ask. She explained that she didn't have any. He kept persisting. He then saw what she says was a status picture of herself fully clothed, that anyone could see. He says that's a photo that was sent to him, but whatever it is, what they agree on is that he said, asked her to send one with the top half removed. Under cross-examination, the Judge President explained this by saying that the reason he'd asked that, Kulula Mtla, was because in the photo she was covered up and that he could not see her shape. And you'll recall he even made a hand gesture during cross-examination to depict the shape of a woman's body. You'll find that on day 8, 9 July 2025, pages 27 to 29 in the transcript. So and then from there on, the conversations escalate. The sexual content, which my learned friend calls salacious. I don't like that word, but the content of the conversations were sexual. When one looks at that, they escalated. They became more persistent, more frequent, and more sexual. And when one sees how these things escalated, from asking for a photo to asking about sexual positions, for example, asking to be intimate, saying it was possible that they would melt if they were together. We would submit that when one looks at that in context, it is not improbable that on the 14th of November, that the respondent called Ms. Mengo to his office, that he then escalated things even further and attempted to unzip his pants and pointed to his penis. That you will see that evidence in day 6 of the transcript, 20 January 2025, page 66 to 67. Now, on the question of the 14th of November, the chairperson asked a question around Ms. Mengo's credibility around the 14th of November, and if I understood correctly, the chair suggested that her inability to decide whether it was the 14th or the 15th of November amounted to a question around her credibility. If I've misunderstood the question, Chair, you will correct me, please. Let me say this, factually, at all critical points, Ms. Mengo has been clear that she was not sure if it was the 14th or 15th. She said that from the first time she reported this officially to Mr. Krokwana. And even then she said it was the 14th or the 15th. And he confirmed this in his evidence under cross-examination. You'll find that on day 5, 9 May 2025, page 47. When she was, we then had a tribunal meeting, like a case management meeting, I forget what they were called, a tribunal inquiry meeting, I think it was called, when Ms. Mengo's legal team were asked expressly to obtain a date from her. And if I recall correctly, it was for purposes of obtaining video footage. But she was asked to pin her colors to the mast and give a date, 14 or 15. And her legal team took instructions. There's submissions before the tribunal. And her instructions were that, to the best of her knowledge, it was the 14th. That's the first time she said it's definitely the 14th. And that has been her position in evidence since then. She was specifically asked on the 23rd of January under cross-examination about this, and she confirmed that as far as she knew, the correct date, as far as she could recollect, was 14 November and not 15 November.
Who came up with 15?
I think in the affidavit, in her complaint, she said there was language used around the next day. I think the language was the next day, which then suggested the 15th, and that raised the question. And she did testify that she wasn't sure and that she had tried to put together things that had occurred in that time period to pin down a date. But what's important is that that she has, it's not that she was inconsistent in her version. She has been clear that she wasn't sure it was the 14th or 15th, and when her legal team were forced to put something on paper, we asked her, and she said, to the best of her knowledge, 14th. Now, the respondent is at pains to deny that the incident of 14 November took place, and it is interesting that that there is a vehement objection to the fact that the 14 November incident took place and to certain WhatsApps, sexually explicit WhatsApps. There's a denial that those took place. Those two things seem to be of particular concern. Now,
I think there are problems around that issue. Isn't there a time when she was asked to indicate whether it was in the morning or in the afternoon, and she was not able to clarify whether it was in the morning or in the afternoon?
Chair, I can't quite recall. I'm happy to check and come. I don't want to make a submission that's not correct. I can't quite recall whether there was an issue of morning or afternoon. I'll check.
I think it was sent out that she should tell whether it was in the morning or the afternoon. I think the chair requested that she tells us whether it was in the morning or in the afternoon.
I'll have a look at the transcript and see what was said. But we would submit that the respondent that the video footage that we saw and the concession by Ms. Nkai show that there was an opportunity and an occasion for the incident to have taken place on the 14th of November. Ms. Nkai said she could not say, she was not watching the Judge President's office all the time, and she did leave her desk. She conceded that. So it was possible, and there were other concessions, but it was possible that it could have happened. And we would submit that given this gradual escalation of sexual demands from the complainant, that it is more probable than not that the incident on the 14th November did in fact take place as she describes it. But even if this tribunal is unable to find that the incident of the 14th of November took place as she alleges, we submit that that does not negate a finding of sexual harassment here. That the remainder of the respondent's conduct evidenced on the WhatsApps alone, even if one is not even to look at all the WhatsApps, but simply to look at what he admits, we submit that that constitutes sexual harassment and gross misconduct. And the same applies to the other issues that he denies, the photographs, K8, 9, that he denies having sent. If this tribunal is not comfortable making a finding that he did in fact send them, and we submit that you can make a finding. Mr. Moller confirmed that he could not rule out that the respondent had in fact sent them from his phone. But if you find that you can't make that finding, even so, we submit there's blatant sexual harassment here. The truth is, if one would just, well, I'll come back to this in due course. Let me keep moving for now. Now, if I can move on to the last substantive section that I'd like to deal with, which is just to try briefly to provide a response to some of the respondents' arguments that come up from the heads of argument. There is a refrain throughout the heads of argument, and there is a substantial section of the heads dedicated to this, that the complaint has only been made to embarrass and humiliate the respondent publicly. It's contended that the way in which this complaint has been handled by the complainant's team, legal team, and the evidence leader asks this tribunal to adopt legal principles specially tailor-made for the identity and personality of the accused, and I quote from the respondent's heads, to venture into some public humiliation exercise in the hope of evoking public outrage against the respondent. That is at the respondent's heads, page 5, para 7 to 8. So we would submit that's a suggestion without any merit. It's quite frankly not borne out by weeks of evidence and the documentary evidence that is before this panel. That's particularly in circumstance where the manner in which the respondent has allowed his defense to be run on his behalf involved a particularly brutal and humiliating cross-examination of the complainant over the course of 4 days. He permitted her to be, because he gives instructions to his counsel, he permitted her to be called a liar, to be accused of acting on behalf of some unknown third party, to be accused of undermining the broader cause of sexual harassment for other women, for all women, amongst many other things. So if anyone has been humiliated and demeaned in these proceedings, it's the complainant. What we saw unfold during cross-examination was enough, quite frankly, to put back the very noble attempts of our legislature and our judiciary to protect women from the scourge of sexual harassment. And the fact that the Judge President thinks that the way in which the complainant has run its case is designed to humiliate him really bears no resemblance to any facts that this tribunal has had placed before them. If the suggestion is that the fact that the Judge President had to sit through a reading through of his personal WhatsApps that he admitted to having sent, and to suggest that this was demeaning and humiliating, then it suggests that he knows that his own conduct was inappropriate and contrary to what is expected of a judge. Now, another argument that was raised for the first time in cross-examination of Ms. Vetten was that the Judge President, it was put to her that the Judge President would contend that what we see playing out in the WhatsApps was in fact a Xhosa cultural practice, and that actually what was happening was that the Judge President was courting Ms. Mengo, and that this practice requires, on his evidence, persistence, and in effect not accepting no for an answer, because the way in which the practice evolves is that the woman has to be coy and pretend to refuse a man's advances until eventually she gives in and accepts a relationship with him. Now, the Judge President claimed that the use by Ms. Mengo of the monkey with the closing eyes emoji gave him an indication that that is what was happening, that when she used the monkey with the closed eyes emoji, she was indicating shyness, and that meant that they were engaged in this practice. Now, that defense was never raised with Ms. Mengo. It wasn't put to her. It wasn't put to any other witnesses. It wasn't raised in the Judicial Conduct Committee. It was raised for the first time in these proceedings. Was not raised in the response affidavit. So this tribunal doesn't have the benefit of Ms. Mengo's response to that particular argument. But she was asked in evidence about what she meant when she used the monkey emoji and with the closed eyes. And it is notable that she did not mention being coy or shy. She said she was embarrassed. It was there to connote embarrassment. So her version is different to his on this. But in any event, the Constitution is clear. Everyone has the right to participate in their cultural practices, and the language of the Constitution is the cultural life of their choice and to practice their culture. But no one exercising these rights may do so in a manner that's inconsistent with the Bill of Rights. So in other words, a practice of culture must be consistent with the Bill of Rights. And ignoring a woman's refusal to be intimate with you or to send photographs of herself, clothed or otherwise, is self-evidently, we would submit, in conflict with her right to dignity and her right to equality, amongst others. So on the issue of the cultural practice, one, we submit this tribunal ought not to take that into account because it wasn't properly placed before you. It wasn't put to Ms. Mengo or to any other witnesses. And it's an opportunistic argument that was raised only under cross-examination of Ms. Vetten. Two, even if it is an argument that this tribunal wants to consider, we would submit that this tribunal must have reference to the Constitution and must take note of the fact that such a practice would, we would submit, not survive constitutional challenge for the reasons I've articulated. Now, to move on to the next issue. And again, these are issues that have come up through the respondents' heads of arguments. The respondents contend that the respondent could not have known that his conduct was not welcome. And they say in their heads of argument, and I quote, "Quite how the respondent in this case ought to have known that his overtures would be unacceptable is unclear." That's at paragraph 65. Well, I've made submissions this morning about various objective facts that he ought to have taken into account and that this tribunal ought to take into account in determining whether or not the conduct in concern at issue was welcome. But what's interesting in how the Judge President chose to deal with the situation in which he found himself as a judge is that he did not once stop and question his behavior. He did not question whether it was appropriate. He ought to have, had questioned whether this conduct, this sexual relationship with her, with a secretary, had the real potential to be unwelcome. The first time that he asked her if he wanted to just be friends came weeks after he'd been engaging in this kind of relationship. On day one, he asked her for he sexualized the conversation. On day one, he ignored the fact that she was very clearly refusing to provide him with what he wanted and making up excuses. I'm at the gym. I don't have any pictures of myself. I'll take some later. All of that happened on day one. On day one, he asked her for a photo with the top half removed. So it is, we would suggest, misleading. We would submit that it's misleading to say that the Judge President could not have known that his conduct was unwelcome. It is possible that there were instances in the conversations where he wasn't sure. Absolutely. We don't deny that. But what is absolutely clear is that sexual harassment happened on day one of this engagement, and it happened in various conversations thereafter. We do not suggest that it happened in every single conversation, but that is why Ms. Vetten's evidence is important. Sexual harassment, you can consent, she said, to one thing, but not to another. Sexual harassment must not be looked at here in relation to the whole WhatsApp conversation as if something that took months, that you're asked to look over months of communications to determine whether that was sexual harassment. Sexual harassment happened here on various instances in those months, and quite frankly, it happened on day one. That's the very clear, obvious finding we would submit. And we would submit that a reasonable person in the position of the respondent would, at the slightest suggestion that she was not responding to him or ignoring him, not have persisted by sending listening ear emojis or prompting her with comments like "twaka," silence, but that a reasonable person would have stopped engaging with her on issues of sexual content early on. And a judge in that position ought not to have engaged with her on these topics. So when the respondent asks how he was meant to know that his conduct was unwelcome, that is how he was meant to know. A judge has to, in all conduct, personal or professional, maintain the highest standards of integrity. To engage in a conversation like this where he asks for sexual pictures on day one that he first starts talking to someone is highly inappropriate. He ought to have stopped communicating with her. As soon as she refused to give him photographs. On the question of, which was asked to the evidence leader by the chairperson about Ms. Moreletwe, the question seemed to suggest that that the fact, let me start here. There was a dispute between Ms. Moreletwe and the complainant about when Ms. Moreletwe left the complainant's hotel room. Ms. Moreletwe said it was 9 o'clock, the complainant said it was midnight. And there was a suggestion that impacts on the complainant's credibility because she made up this midnight time as a way to challenge Ms. Moreletwe in some way. Now, we would submit Ms. Mengo didn't tailor a version or produce a version to attack Ms. Moreletwe. She was consistent that it was midnight. She was cross-examined about it. She was consistent it was midnight. In fact, she even says she gave Ms. Moreletwe a thank you card to thank her for staying late because it was so unusual for her to do so. She says the next time not the next day, but the next time when she came back to Pretoria, she gave her a thank you card specifically for staying so late. And that you will find in the transcript of 8 May 2025 at page 7. And it does not assist Ms. Mengo to lie about this. It does not assist her to say that she left at midnight instead of at 9 o'clock. But what is clear is that that even when challenged, Ms. Mengo was consistent. She said she stayed late, it was midnight. It was so late, I thanked her specifically. Then the narrative that the complainant...
I must tell you, I think we don't understand it the same way,
okay.
the same context, because the bottom line of complainant's evidence is that when she was in Makanda to compile what she says was the second complaint, she didn't have any copy of the initial document. Lo and behold, these documents are identical. Even the grammatical errors are identical. With all due respect, it makes nonsense of the argument that she didn't have a copy of that one. It must have been embedded either in the memory stick or in her laptop. But my problem is this. She extends Moretlo's stay at the hotel in order to pave the way for the argument that she was not left, she did not have any copy of the document embedded in her laptop or in the memory stick. To perfect that argument, she extends Ms. Moretlo's stay at the hotel to 12 o'clock.
Chair, that is an argument that we would refute, that we would say it doesn't have merit. She said it was midnight because she is insistent that that's when it was. This tribunal will make a finding on that. But what is absolutely clear is that even this thing of the two complaints is a bit of a red herring. You can talk about her credibility, but go back to the WhatsApps. When you have to look at misconduct, when you have to look at what this tribunal has to consider, look at the WhatsApps. Look at the fact that Ms. Mengo hid nothing from this tribunal. She did not, and in fact, that's the next thing I want to talk about, which is that there is a suggestion that she tailored evidence, that she came up with versions. But if that was the person that was before you, she would not have given you every single WhatsApp on her cell phone after 2 years of having that phone. She provided that. She may have attached some of them to her complaint. But we've seen how many pages those WhatsApps run to. She took screenshots of some of them and attached them to complaint. But when the complaint proceeded and she was asked to give her cell phone to the evidence leader, she handed it over. And what we have before us is a full set of WhatsApps, that many of which make her look bad, quite frankly. If she was the person that was sitting here trying to construct a version, she would, I submit, have deleted things that made her look bad. She did not delete them. And when she's asked about the things that are difficult for her to answer, she says, I don't know, or I was frustrated, or I said this because I was being sarcastic. She tries to engage with it. This is not someone who's trying to hide evidence from this tribunal. In contrast, the respondent has deleted every single message from his cell phone. He admits to having done that. He didn't want his family to see it. That's what was his evidence, as I recall it. So you're faced with a situation in which this complainant, as we submit, come here, she may not be entirely consistent on every single fact that's put to her. But no complainant in a matter like this is consistent, can remember every single date perfectly. And if there are things that are inconsistent in her version that you find to be problematic, they do not negate the fact that you have WhatsApps before you that show sexual harassment. And once you have sexual harassment, you must get to misconduct. Now, Chair, we will submit that this case requires this tribunal to assess the conduct of the Judge President and to determine, as we've said, whether his conduct amounts to gross misconduct. The evidence is lengthy and voluminous, and it requires this tribunal to venture into realms of WhatsApps and emojis and sexual innuendo. It's messy, it's uncomfortable, it offends our sensibilities, but it must be done. And as the tribunal does this exercise, embarks on this exercise, I would ask the tribunal to bear in mind that the expert evidence before you and the evidence of the code on good practice under the Employment Equity Act says sexual harassment is not just one incident, it's persistent, but it doesn't have to be. And what we see in these WhatsApps, as I've said, is that day one of the WhatsApps constituted sexual harassment. This panel must therefore ask itself, on a conspectus of all the evidence, whether the conduct of Judge Mbenenge, not the conduct of Ms. Mengo, the conduct of Judge Mbenenge is conduct which is acceptable of a senior judge and leader of the judiciary, and whether it's conduct that if it was repeated by other judges in the future would meet the standard that we require of our judges. If not, then you must find him guilty of a breach of these standards and of gross misconduct, for the simple reason that he ought, at a minimum, to have known that what he was doing was wrong and in conflict with the requirements of his office. And so we would therefore ask this tribunal to find Judge President Mbenenge guilty of gross misconduct. Chairperson, I haven't dealt with various things that are in our heads only because you've given us an indication not to do so. You've read the heads carefully. But if there are other issues, I'm happy to deal with it now or in reply. Thank you.
One of your early statements, Advocate Bartlander, was, this matter is not complex. I don't know, I'm not sure whether I should agree with you.
Chair, I said the question for you was not complex. The matter is complex, certainly.
At the end of the day, isn't this the question? Well, let me say, actually, should we find that the respondent persisted with his communication with the complainant, even though it was clear that his messages or his approach was unwanted. Unless Mr. Sikakani argues otherwise, the likelihood is that we'll find that there was sexual harassment. If somebody persists in a conversation like that, where it is clear that communication is unwanted, the likelihood is that we'll find sexual harassment, which therefore means that the real question in this case is where this message is unwanted. Is it clear that these messages were unwanted? I think that's the main question. And then we'll have, in answering that question, there are a lot of factors that we'll consider, and so forth and so on. And perhaps, as they say, the devil lies in the details. And there are so many aspects to this case, which we will consider. But what I would like to raise is, I think maybe I asked for this, about the messages that if we find that have been initiated by yourself, we have discussed that. Were there any flirtatious messages from her If we find that there are flirtatious messages from her, then what do we do with that? But your argument is there were no flirtatious messages from her.
Yes.
Is that what you say?
Yes, we can't deny that there were messages in which she responded to the sexual questions, like when asked, I don't want to put the wrong words to the panel, but you recall the incident where she said, she was asked once about sexual positions, and she said she likes the word surprise, something to that effect, I'm paraphrasing. We don't deny, and we put to her, we said to her, why did you engage in this way? And she had an answer for it. And her answer was, she just had enough. She'd said no so many times and he wouldn't accept it that she thought maybe if she engages with him, he'll leave her alone. So she had an answer to that. But what's important...
No, but hang on. If the respondent suggests
that
sexual
shows that it was
position,
wanted.
and then she responds, she's not keeping quiet.
But
She
sorry.
says she's not saying no. She actually says, I prefer a sexual position which comes as a surprise. That is actually an elaboration on what was initiated by them. She didn't initiate that, of course, but then it's an elaboration.
No, it's a response. She said, I like the word surprise. We'll pick up the exact language for you. But the point is, Chair, that's why I said, you must not look at a line out of context. You must look at these WhatsApps in context. So you must look at a conversation. And Lisa Vetten said that in her evidence. She looked at conversations. Look at a conversation in determining, whether or not, whatever the question is you're asking, whether there was misconduct, whether there was sexual harassment, whether there was consent. But the point is, the context is important, and when you look, you have to read, I keep saying you have to look at all the WhatsApps so that you see what I call the escalation of this relationship. It's not that this one question about sexual position comes out of nowhere. It comes at the end of months of engagement around this and pushing the boundaries to ask more and more sexually explicit questions until she gives in and answers. So that's why I say the context of the conversation is important. One cannot say, and it was not open to the Judge President to say that in relation to one question, she answered in a way that suggested that that was wanted. That question may be fine. But in relation to all of the many other instances in which he suggested sexual things to her where she refused to respond or evaded, tried to avoid the question or ignored him, those were not wanted. And the truth is that if an ordinary person has to have this engagement with someone else, that's the question. What would a reasonable person think when you look at all of this evidence? We would submit that what is clear is she wasn't a willing participant in this. She was a woman in a position that she didn't know what else she could do. She tried saying no. She quoted the Bible. She refused to send things. And then she gave up. That doesn't mean sexual harassment didn't happen. It doesn't at all. Sexual harassment happened because if that were true, then we could never find sexual harassment because sexual harassment has as one of its elements persistence. And the persistence is designed to break down your boundaries. So if it is okay to say that eventually after all of this persistence, when someone engages with you on sexual talk about your favorite sexual position, then that means that she wasn't sexually harassed from the beginning. That would be a wrong finding in my submission. It's also not, these issues are not being dealt with by this tribunal for the first, well, it's been dealt with by this tribunal for the first time, but these are issues that our courts have grappled with. Our labor court jurisprudence is replete with cases of sexual harassment and how to weigh up all of these things. And what that shows is that there are complexities around this, and it's not a simple question of, did you say no? I asked you for a photo, you sent a photo, and if you sent it, that was enough. It's not about that. In fact, she never sent a photo. But it's really about listening and reading Ms. Vetten's evidence to understand what people study about gender relations in this country and how men and women engage. That's why I say the way in which Ms. Mengo responded and how she chose to respond, it's not a simple thing. This is a complex thing. The fact that we're having these debates shows how complicated it is.
And you see, you spoke at length about the issue of power. Advocate Scheepers also referred to that. But you know what Mr. Skakane's argument was, an engagement with Dr. Vettel. And I got the impression that Dr. Vettel's evidence was that from A to Z, I don't know whether my impression is correct. It was as if from beginning to end, in terms of power relations, at all times, at every turn, the JP was dominant from A to Z. Now, I don't want to get us entangled in that, except to say that the matter here too is not that simple. You know, a woman has been given by God, or those who don't believe in God, let's say by nature, with the power, absolute power, to decide who has access into her heart. That key lies in her hand. There's not even a duplicate key somewhere, like duplicate key to a Mercedes. That key to her heart is under her absolute control. Now that's the beginning of power, indication of power. And I become curious, if not uncomfortable, when a witness comes to say, from beginning to end, there was no display of that power by the complainant or by a woman. In this particular case, when Ms. Mengo says, I want money, isn't that an excess of power in terms of interaction? Is it not an assertion of power? The question should be asked. If you say you want pictures or what, I want money, isn't that an assertion of power? And when she says, when the respondent asks for something, she says, "And it," isn't that an assertion of power in that context? And when the complainant sends a message to the respondent, and she says, "I would like the two of us to meet," isn't that an assertion of power? I want us to meet at the time of my convenience, that is when she's available. I want us to meet in East London, at my place. In that context, is that not an assertion of power? And the respondent, if she wants to meet with the complainant, it is at the complainant's time of convenience, which she is saying in the message. She's saying, she decides which city they must meet. She says in East London. And I don't think the mighty Judge President can, on that occasion, when he has got to go and meet, can go to Port Elizabeth when the message says East London. She chose East London. If he wants to meet with her, he must go to the city chosen by the complainant. And he was keen to do that. And then she says, in East London, at my place. Isn't that an assertion of power in that context? If you want your respondent, he wants to meet. If you are in the position of the respondent and emotionally you are overwhelmed or mesmerized by her, what power do you have except to agree to come to go to East London and to her room? And you have got to go to East London. She chooses the city. And she says, when in East London, you come to my place. In other words, when the respondent has got to go to East London, he can't go to the city hall. He cannot go to the city hall. If he wants to engage, must he not meet complainant's terms at the time of my convenience to the city that I choose at my place? And isn't that, in that context, an assertion of power? And then, the matter doesn't end there. I just want to show you how complex this issue is. The matter doesn't end there. The respondent says, when we are there at your place, what if we melt and something, can we become intimate? She says, no. To me, it's an assertion of power. We can't. Why would it not be argued that these instances I've mentioned, and the one we mentioned before, where you say about sexual positions, she says, no, I don't go for that. I prefer a sexual position which comes as a surprise. It is her body. She's got the right to say that. It's her heart. Why should it not be seen also as, at least in that context, some assertion of power, the power that she has about herself? In that context, isn't that an assertion of power?
Chair,
You know, I'm trying to say to you that we must be careful with how we engage these complex concepts of power relations. I mean, if she says, come to me and come to my place, I forget Batlinda. Ordinary life will tell us that Zelensky, if he wants to talk to Trump, or Trump wants to speak to Zelensky. Trump can't go to Zelensky. Zelensky must go to Trump. Ramaphosa must go to Trump. Why? It is purely a question of power. You go. Zelensky is in a weaker position and power-wise and so forth. They must go to the big Trump. Now you have a situation where a lady says, if you want to see, I want you, for us, the two of us to meet face to face. You come on at such and such a date which is convenient to me. You come to East London and you come to my place. Isn't that an indication of some power? I mean, for somebody to come here and say, from A to Z, there hasn't been any case of assertion of power by a woman, and a woman is always powerless, it's quite surprising. And look, I said to you that the woman has got power. We must recognize that when it comes to matters of heart. You know, when a beautiful, charming, elegant woman is there and a man wants her heart, and the man comes to her and then she says to him, you want me? Catch the stars for me. A man will jump and try to catch those stars. That is an assertion of power. And when a man wants to marry a woman and whatever, or when that moment comes, where does power lie? A man goes down on his knees, kneels in front of a woman and says, will you please marry me? That you kneeling in front of somebody, you humble yourself to the power that person has. So this notion that a woman may not have power, is it really well founded and real? in relation to matters of heart, in relation to control of that key to her heart, over which she exercises that power. That's why you'll kneel in front of her. In that given situation, who is powerful? You humble yourself. So situations arise where a woman can assert power. And for anybody to say that a woman cannot assert power in any situation is an astounding evidence.
Chair, we do not suggest that there are no circumstances in which a woman has power. What we're talking about here is a workplace. We're talking about an engagement between the most senior person in a workplace and one of the most juniors. That's when we talk about the balance of power, it's in that context with what Ms. Vetten said. But in her summary, her witness summary, she talks about what I think you're alluding to, which is that Ms. Mengo, she says, attempted to exercise some agency within the limitations permitted by the complexities of this arrangement. On occasion, she resisted Judge Mbenenge's repeated transgressions of her boundaries in ways that were sometimes explicit and direct, as in refusing to provide photographs or engage in sex, and at other times in ways that were implicit, indirect, and ambiguous. There is no one strategy for dealing with sexual harassment that works under all circumstances for all women. Now, and then she says finally that her changing responses are in keeping with the many ways in which women seek to accommodate, negotiate, and resist sexual impositions. Now, first of all, that's the context in which we're talking about power. But, Chair, I want to suggest, and I've already said that I don't suggest that women never have power. That's not the suggestion at all. The balance of power is that. It's a balance. It's a shifting balance. I accept that. That was what Mr. Sikakane put to Ms. Mengo, that the balance of power may shift. Sure. But to suggest that women always have power and that women, as the Chair puts, have power over their heart, which here we're not talking about power of your heart, we're talking about power over your body. We're talking about an invasion of your most inherent private spaces. Sexual harassment is not about romance, it's about power and sex. And if it was that simple that women held that power to who they allow to invade that space, who they allow into their body, then we wouldn't be a country with the highest rate of GBV in the world. We wouldn't be that, because women would have that power. But that's why I say we're not talking about that. We're talking about a workplace context here. So it is in different situations, in romantic, consensual situations, yes, it may be within a woman's power to say, I accept you as my partner, I don't accept you as my partner, I want to have sex with you, I don't want to have sex with you. Yes, in perfect, consensual relationships. That's not what we're talking about here. This is an engagement between, as I say, the most senior and one of the most junior people in a workplace. And in that context, even where Ms. Mengo exercises her voice where she can. So I want to just, I think the Chair's incorrect about her saying, you must come to East London, you must come to my house. Her evidence, and I've asked my attorney to try and find the transcript reference to you, the evidence was that she wanted to sit down and tell him face to face once and for all this was not okay. And the suggestion was they meet at court, not at her house, because that would be a safe space. He wanted, there was another instance where he wanted to come to her house, and he asked if there were people there, and she said yes. He asked, I'm just looking at what the evidence leaders provided me, if you'd bear with me. Yes, if one looks at the transcript, transcript page 1207, sorry, I think it's 1207 of the WhatsApp conversations, the respondent says, upon your arrival in East London, where will you be? And she says, my house. And he says, or we will have the conversation at the office. And she says, better. So it wasn't that it was going to happen at her house. But I haven't, this is what the evidence leaders
can I just try to define you what, sorry, I appreciate your point about that. What I'm saying is, when a person comes to say, I mentioned the word A to Z, I don't deny that there could be that, but when a witness comes to say, looking at this case, there is no stage at which she exercised, the woman exercised power. It becomes problematic.
That's not what she said, though. That's why I read this
Well,
part
that
of
is
her
the
evidence.
that is the impression I got. If I'm wrong with Dr. Vettel's evidence, that if I misunderstand her evidence, to say throughout, there was no time, there was no occasion at which there's some indication of assertion of power by the complainant. I thought that was the evidence. If I'm wrong, then what I put to you must be incorrect.
Well, I've read, Chair, from her summary. I don't have her transcript before me, but my understanding of her evidence is that there were instances in which Ms. Mengo tried to assert some agency, is her language, within the limits of what she was able to do. And that agency was, for example, resisting or being blunt or where she's sarcastic. But the real point on the balance of power is this. It comes down to this. If Ms. Mengo had done something to upset the Judge President, she was doing something in the context of her workplace to make the most senior person in her workplace angry with her or upset with her. I'm simplifying. But that's the balance of power. The balance of power is that in the context of her job, where someone in the context of your job makes sexual advances to you and you rebuff them, you are not sure what the consequences are going to be. And that's why sexual harassment in the workplace is such a difficult thing, that often it goes unreported because you're not sure what the consequence is going to be if you report it. So that's the balance of power. It is the same, for example, in a context that we understand as lawyers, that if a junior advocate was to rebuff a senior counsel that she was working with on a case, that she's not guaranteed that she will get work from him again, or she's not guaranteed that he won't tell other people that she's bad. So the balance of power is in the context in which it happens. It's in the workplace, and that has a particular importance to it. So when we make arguments about the balance of power, it's balance of power in the workplace. It's not balance of power in a consensual relationship where someone proposes to you and you have the power to say, I'm not interested. It's not that. But even in that, there are instances, Ms. Vetten recognizes, that Ms. Mengo tried to assert herself and tried to use what power she had. On the question of the money, it's not that she just asked for money. She said, if I were to ask you for money, would you give it? And her explanation when she was cross-examined on that was, I know that if you ask a guy for money, they run away. And so it was her attempt to say, let's end this thing. I'll ask you for money. And he then says, money is not everything, and she agrees. So, and that's it. And notably, she never once after that asked him for anything. She didn't ask him for a handbag. She didn't ask him for money. She didn't ask him for a holiday. She didn't ask him for anything else in the course of all of these months. And one would imagine that if what she wanted was in fact this kind of reciprocal relationship, that she might well have done so. But it's notable that she didn't. So
there was something I wanted to ask.
No, go ahead, Chair.
For you to speak to it now before
Yes.
Mr. Skakani speaks out. I think you have alluded to it. And that is that the question of the omission of a series of messages, which Mr. Skakani, I presume, I would like you to deal with it to save time, even before
Yes,
it
sure.
comes. Which, some of which would show that she was not amenable to the approach. And the argument, if I understand it, is that a series of them were not alluded to in a complaint. And they were left out. And I don't know whether the argument is that they were exhumed by Mr. Moller. A series of messages which she allegedly left out and didn't even refer to them in a complaint, and that these messages were indicated that she was amenable to that. I could have left it to Mr. Skakane to develop his argument further, but the interest of program or progress, and just to give you a full platform to speak to that.
Yes. No, thank you, Chair. I've alluded to it in my attempt to rush through my submissions, but...
You alluded to it, you referred to the fact that some messages were deleted, blah, blah, and so forth. You referred to that, but
let
I
me
want
clarify.
to put it more pertinently.
The allegation is that when she filed her complaint, that she did not put every WhatsApp in that you now have before you in this tribunal. And so there's a sense that she was hiding things from the complaint. The first point is, when she did that complaint, she was doing it on her own. She wasn't legally represented. When she did the complaint, she wasn't advised as to what she should or shouldn't do. But in any event, the Act does not require her to put all her evidence up before attached to her complaint. I was just trying to find the exact language of the Act, but I'll find it and deal with it in reply. But the Act requires that when you make a complaint, that you must state the basis of your complaint and the, I don't want to summarize, but it does not require evidence. That's very clear. She didn't have to put every single piece of evidence. What she said she did is she took, when she was with Ms. Moreletwe, she took screenshots of what was on her phone, and then she started printing. And those are the things that found their way into the complaint. But she didn't hide evidence. That's our submission. It was what she thought was relevant. Now, whether she should have attached more, maybe this panel will find that, and in future complainants will know you must put absolutely every bit of evidence attached to your complaint. The point is that she kept that phone. She kept the phone with all the WhatsApps, everything. And she provided that when asked. She could have deleted
some of
things.
them were deleted.
No, what you have before you includes, there were things that went missing when she provided to the SAPS. She says that. But what you have before you is everything on her phone, which includes things that are not complimentary of her, which includes things that if she was hiding things, she would have deleted. We know that because she was cross-examined extensively on this vacillation and whether it was in fact unwanted attention that she was getting from the JP. Because she left in there the full conversation between them over months. So this kind of narrative that she somehow hidden evidence, we would submit is wrong and it's misleading. It's not that. It's about what she chose to attach to her complaint, having no obligation to do that. In fact, she didn't have to attach anything to a complaint, but she did. And when asked to provide evidence to this commission, she provided it, all of it. So we would submit it's a bit of a red herring. But I can deal with it more in reply if necessary.
When the JCC considered the matter, you can attend to that.
I'm so sorry. Okay, go ahead.
When the JCC considered the matter, did they have all the WhatsApp messages that we have now?
No, they did not. The JCC was required to see whether there was a prima facie case. They had the complaint and what she attached to the complaint, and they had submissions. They didn't have oral evidence, I think. I wasn't involved at that point. There wasn't oral evidence. But they had, Ms. Mengo at that point was legally represented, and there was submission, and as was Judge Mbenenge, and there were legal submissions made on behalf of both.
Do we know what conclusion would they have arrived at had they had all the WhatsApp messages?
We do not. But I stress there was no obligation on her to provide all the evidence attached to her complaint, and I'll find that provision in the Act here. When a person complains, they are not a lawyer. Mostly, they may be advised. She was not advised. So one must be cautious about what we require of complainants. If what we require of complainants is to make a full case, including all your evidence, then we must say so. But the way in which the Act and the rules are structured suggests to me that that's not the case, because the JCC referred it to this tribunal to hear evidence on various issues that may or may not have been at issue for them, or an issue for them. That was the purpose of this tribunal.
Yeah, but that's not the point.
Now, I
The
understand
point is, you may not disclose everything, but at the same time, you can't omit that which is not favorable to your case. You can't.
No,
You
sure,
must
she
make
just,
an-
I
you must
can't-
make an honest disclosure.
Yes, all I can say is that she took screenshots of what she thought showed sexual harassment, which was her complaint, and she attached it.
Yes. Mr. Skakani. Sorry.
Thank you, Ms. Butlander. I heard you mentioning that the complainant never sent photos to the JP. Is that correct? Because of, my memory serves me well, the JP said there is one photo which she sent to the JP, and the JP commented on that particular photo, which the JP sent, which the complainant sent to the JP. It was not a profile picture. That's how I understood the testimony of the JP. So the assertion that the complainant never sent a photo to the JP, is it correct?
It depends what photos you're talking about. She, for example, kept posting pictures on her status. So, for example, the picture of her food, a picture of herself dressed, and he would comment on those. There's a dispute about whether some of those were sent to her. She says they were her status photos. But if you bear with me, I just want to check one thing with my attorney before I give you a full answer.
Yeah, but the way I understood the JP to be saying, in one of the comments, it was not a status. It was something, it was a photo which was specifically sent to him by the complainant, which is different from when someone picks up a profile picture and makes a comment. And he tried to make a distinction between those two, to say, but hang on, there was an instance whereby she sent me specifically a profile, not a profile picture, but a picture, and I commented.
A picture of herself?
Yes.
Can I check with my attorney?
Please do so.
If you'd bear with me for a minute. Mr. Mashaba, I think that what you're referring to is potentially at page 1167 of the WhatsApps, where there's a photograph that that the JP responds with the, I don't know what emoji this is, fingers touching, saying stylish. And there is a dispute between the parties about whether or not that was a picture she sent him. She says she didn't. She said it was her status that he was responding to. So there is a dispute on that issue. But she says she did not send him pictures.
Lastly, on the issue of the no, you say there were 11 no's. Are you referring to the ayes? Because I think...
No, in fact, I will provide a table just to clear up any concerns. There were a series of ways in which she said no, this is a submission. There were some times where she said the word no. There were other times where she quoted the Bible verse and referred to the first word. There were other times where she said no in different ways. It is impossible. It will not happen. You must control yourself. There were, when I say how she said no, it's how she, perhaps it's better to say how she rebuffed him, how she was trying in many different ways to say no. And I'll provide a table with all those references. This morning I counted 13, but I will provide a table to the panel.
Excellent. Thank you.
Mr. Skakani.
Yes, Chair. Thank you, Chair. I won't be long. May I ask for a short break? Remember, there were paragraphs I wanted. My team just walked in when we were coming back. I just went for 5, maybe 10 minutes.
All right, maybe let's say 20. Yeah, maybe let's just have
Half
a
past.
tea break. We come back quarter to?
Yes, that suits me. Thank you,
Quarter
Chair.
to 4, quarter to 5, quarter to 6, quarter to 7. Mr. Sikakane.
Thank you, Chair. And
I must indicate to you that we indicated that we need to finish, but please don't feel pressured into finishing when you don't want to finish. We'll be willing to stay on here forever if that needs be.
I'll finish before 12. Chair, and thank you very much for the opportunity. I won't be long. I think first let me start by saying we say no more than what's in our heads of argument. And we've given it there in greater detail than we should. And I think it curtails the time we should spend today, oral argument. And may I also indicate that in view of what the chairperson asked for, there is a bundle, not a bundle, it's just heads of argument, with references to those specific paragraphs that the chairperson indicated lacked referencing. So we've done it in there. There may be one, I think it's 349, that may not have it because it's simply a generalized comment on the nature of the evidence as a whole. And so that is not there. Chair, before I set out the scheme of my submissions today, let me just read one of the two cases that I think the tribunal must read together to understand what the truth is about sexual harassment and what factors must be considered. But I quote this because I don't want an understanding, a line that there's another tone in our argument that does not recognize the seriousness of sexual harassment as a scourge. And it's in the case of McGregor versus Public Health and Social Development, Sexual Bargaining Council and others.
It's the same one that...
it's the same one that my learned
Butler
friend, yes. I just want, because it starts with a very powerful clarion call to all of us. And it defines sexual harassment beyond what one finds in the two acts, the Pepuda, and it says, sexual harassment is the most heinous misconduct that plagues a workplace. Although prohibited under the labor laws of this country, it persists. Its persistence and prevalence pose a barrier to the achievement of substantive equality in the workplace and is inimical to the constitutional dream of a society founded on the values of human dignity, the achievement of equality, and the advancement of human rights and freedoms, and non-sexism. Not only is it demeaning to the victim, but it undermines their dignity, integrity, and self-worth, striking at the root of that person's being. Writing in 1989 in its first reported case of sexual harassment, the erstwhile industrial court, sounding the alarm that sexual harassment cannot be tolerated, highlighted that, and it quotes, unwanted sexual advances in the employment sphere are not a rare occurrence, and it is by no means uncommon, close quote. Unfortunately, the truth rings as loudly today as it did then. The only difference between now and then is that today we hold in our hands a constitution that equips us with the tools needed to protect the rights that are violated when sexual harassment occurs. Yet, what this means is that for as long as sexual harassment persists, so the Constitution becomes an eidolon, and its promises of equality and dignity equally elusive. You may wonder why I'm quoting this, because to a naked eye, it sounds like I'm arguing against myself. I'm not. I'm raising this because this is a clarion call to everybody involved in an inquiry about sexual harassment. And it is a clarion call to the complainant or complainants, and a clarion call to the potential respondents in cases of this nature. But of course, it's a double-edged sword, this definition. The seriousness with which we are being warned means determining questions of sexual harassment must be done in a way that is careful, that is unbiased, that concentrates on the facts, so that in future you do not have a broad sweep and a system where any complaint is entertained, even if it undermines the legitimacy of genuine complaints about sexual harassment. The scheme of my submission is as follows. First, that I'll deal with, noting that the comprehensive heads have been filed, is that I'll do a broad summary of this case, of what this case is about and what it is not about. And this I do to avoid repeating certain things. In that first point, I will also deal with the precise definition of sexual harassment, wherein I will argue that there is a definition because we must avoid a generalized approach, one-size-fits-all approach, depending on how we feel. And I will give the definition because there have been a lot of moral questions raised, some of them misplaced, which have tended to dominate the questioning of the respondent and the condemnation of the respondent. And these proceedings, and from the large community of moral high horse riders. The second topic I will deal with is an overview of the evidence without repeating it, the tenor of the evidence. And in this point is to demonstrate, as I start within the heads of arguments, he who alleges must prove. It's a basic principle. And I will show that contrary to the broad sweeping claims and moral outrage about flirting by a judge, there is absolutely not an iota of evidence showing that that flirting, which is not impermissible, that flirting constitutes sexual harassment. And while I'm there on the definition, my learned friend chose to move away from PEPUDA. PEPUDA, the Equality Act, because she says we must focus on the Employment Equity Act. I will demonstrate that it's actually a case of jumping from the frying pan straight into the fire. It is actually in the Employment Equity Act that the word unwelcome as a factor, unwelcomed, is mentioned 8 times. In fact, in the 5 factors that my learned friend sought to rely on, it is there that the word unwelcome is mentioned 7 times, and once in the broad definition. So basically, the two are not distinguishable in their emphasis of what it is that constitutes sexual harassment. Thirdly, I will traverse the general tone of the conversations between the claimant, the complainant, and the respondent. Of course, the point we've made here is the fact that some conversations were concealed. Obviously and ordinarily, no one expects us to be suggesting that in a complaint every point must be quoted. But what we are saying is that the pattern of what was selected reveals a deliberate attempt to conceal that which would reveal this important factor called unwelcome. And if the tribunal feels that, well, that's conjecture, so be it. But what we were raising is not that she should have quoted everything, but that the pattern of selecting itself, selecting particular things that do not really place you in a positive light, is itself a problem in proceedings of this nature. The fourth one is that in as far as there's been an attempt to suggest that the conversations are replete with rebuffs. And this is dealt with largely from page 43 to 44 of our heads. And it suggests that Ms. Mengo was an unwilling partner. It means was unwilling to engage. I will traverse, although briefly, the so-called rebuffs, which in our respectful submission are a creative reconstruction of the conversation, almost undermining the participants in the conversation. Fifth, and we do this from page 44 to 54, I will refer to my learned friend says he doesn't like the word salacious. My own client used the word sensual. I will use three of them: sexual, sensual, and salacious chats themselves, citing different dates. For example, 8 June 2021, 10 June 2021, 18 June 2021, 20 June 2021, 21 June 2021, 23 June 2021, 26 June 2021. We cite these clearly there, and I will not repeat them, but I'll move there when I deal with the argument. And the last two topics, or three topics, and which are dealt with in page 57 to 68 of our heads, will submit that the claim that the respondent sent crude pictures is a patent falsehood. There is no evidence that it happened. And to suggest post facto that we must assume it did because we can't tell that it did not has to be said to be rejected. That it was not shown. We suggest that no evidence showed that such a crude picture was sent. And we deal with this in reference to Annexure H, Annexure H1. And as I said, this is in page 57 to 68 of the heads where it's dealt with. Annexure H8, Annexure K8, K11 and K12, K13, N and P. And we show that the evidence of the expert, Dr. Moller, does not support the claim that such crude pictures were ever sent. We will, in that topic, submit that should be rejected. And most crucially, the respondent eloquently denied it. We'll also show the futility of the expert evidence. And I think most of the questions from the chair about referencing were there. And in this one, we deal with it at page 77 to 92. It's paragraph 230 to 280 of the heads of argument. It's dealt with in greater detail there. And I will try to persuade this tribunal that both these experts failed the test that I had placed, at least we put to them, about at what point is expert evidence to be accepted and helpful to the process. And I cited the tried principles. Lastly, as a topic from page 106 to 114, we deal with what we call fabrication. I'm using the word dishonesties advisedly because I do not wish to attack the complainant there. I think the word is a little harsh, but I think we call them incongruities. I apologize for using the word dishonesties. It's harsher, and I think let's leave it at incongruities and fabrications. At the heart of this is the claim, which we say is false, that JP sent Ms. Mengo a picture of his private part. No evidence was shown to really prove this very, very painful public lie about what he did or did not do. We will also here indicate no evidence, no amount of conjecture can show that on the day of the 14th or the 15th, the incident about which the respondent has been so humiliated that he called the complainant and showed her his private part. painful falsehood, no evidence showed, the footage did not. We will deal with those. And while I'm there, Chair, you asked the question about what was requested from the respondent requested the tracker of the movement of the complainant's car. The evidence leader said, no, that request was not made. Chair, there is a request for particulars that demonstrate that that happened. And in particular, you look at paragraph 1.1.3. But generally, the entire thing demonstrates that what was requested. So we will submit that it is mistaken. And in conclusion, Chair, we will show with reference to what we think are fabrications designed to conceal the fact that the conversations were consensual. And Chairperson, insofar as there were things that were said by my learned friend about which I think are attacks on us as a team or my respondent, you do not need to determine my conduct and whether I was brutal or not to determine this matter. I don't want to get there. I would like to go straight to what the issues of this case are about. On the first topic, Chair, as I said, you are not required to determine how flirting should be done. Whether the respondent does it elegantly or inelegantly is a matter about which reasonable people can differ. How it is done on what others would expect is quite a subjective question. And therefore, the suggestion that the problem is the manner is itself a wild allegation that no one can determine. The narrow complaint of sexual harassment brought by the complainant against the respondent is based purely on several WhatsApp messages between them. And in order for such communication to constitute sexual harassment, it must be related to sex or gender and must have, and this is the important part, unwanted, persistent, serious, demeaning, humiliating, and intimidating or threatening adverse consequences. The first of these is unwelcome. And none of these necessarily must be pulled out. In fact, there's one that has been added about who initiates. It's not a factor. It is not a factor to determine whether people consent in the discussion, to determine who starts it. You must look at the content of their discussion. And so it's for the reason that that factor of who initiates it is not necessarily a factor. It is the content and conduct of the parties engaged in the discussion that matters. The definition of sexual harassment as articulated, and I will use the Equality Code Act, but I will ask the tribunal to use the Employment Equity Act if it so wishes. And that definition says this. It too comes from a whole body of legitimate case law. It's unwanted conduct which is persistent or serious and demeans, humiliates, or creates a hostile or intimidating environment, or is calculated to induce submission by actual or threatened adverse consequences, and which is related to sex, gender. I invite the tribunal to look at both, even the one that I didn't rely on. It will find that it's defined this way, the key being unwelcome. This is the narrow ambit of this inquiry. We deal with this in the heads from paragraph 19 to paragraph 46 in our submissions. This is the classic case. Yes, I agree that it's an important case, but it's an important case because the very essence of the definition, the factor of unwantedness, if there's such a word, is absent. It's absent. It's concocted, reinterpreted, but that reinterpretation itself undermines the participants in the conversation. We can sit here for the whole day, the whole 2 months, trying to analyze in our own condescending way what people mean or what they meant. What matters is what they said and meant to each other. It is this definition of sexual harassment that is the gateway to all the things you've been asked to find against the respondent. How can a judge do this? A senior judge must not do this. A senior judge must not court this way. But first you must find, before you reach whether anything he did was dishonorable. Of course, I wouldn't court the way he does. I find it inelegant. But this is not a competition about how best to court. I do it my own way, or I used to before I got married. And he does it his own way. Yeah, my wife is listening here. But the point is, we are told that relationships of this nature at workplace are not a problem. It's the manner in which he engages. This is a murky area about which most men and women can differ. Some are elegant, others are not, and therefore it would be difficult for this tribunal to get there. What I'm suggesting is this.
Some say you must buy flowers. Some say take her to a restaurant in Sandton, but in Sekhukhune, where do you get a restaurant of that kind?
You know, Chair, we say this in our heads, and it may sound facetious. It is difficult to analyze conversations of people from different backgrounds. It's much more difficult if you come from Western notions of conversation, because you are analyzing something about which you enter being superior, that you think it represents barbarism. It represents, that's why the manner, why didn't you buy her flowers? Why didn't you take her out? Inherent in that analysis is absolute prejudice and condescension about how different people approach this. And I'm not here to argue that the JP courts elegantly. I've already stated that. I don't know, but different people can approach it differently. And so to conflate what you think is an elegant way of asking one out with harassment, which is persistent and unwanted, does not find favor in the evidence that was presented before you. And so we, in the first place, ask that you consider the definition of sexual harassment, which is objective, and you look at the evidence. And that is why we preamble, or we start by saying the necessity of proof always lies with the person who lays the charge. And to suggest that all the complainant must do, or a person who must complain must do, is to simply lay a complaint. After that, we will concoct all sorts of sympathies about how they were feeling and what gender they are and what position they are, is a dangerous approach to it. On its own, as much as it's attractive, it's an attractive, feminist approach to looking at those things, it's a dangerous approach to dealing with issues that plague society seriously. And so one must develop a precedent, not just of being general about this, but to be rigorous. It's not brutal. It's to be rigorous so that we determine the truth. And we say some of it were clearly fabrications. I've already stated some of them. So this definition is the gateway to all the accusations that have been put here. Was the JP acted dishonorably? The Constitution protects everybody, and we must not quote it selectively. And one of the most important things about it, its founding principles, is that what we ask for those who are our clients, we must ask for everybody. And justice is at the center, which means fairness to both the complainant and the respondent. And so selective quoting of the Constitution is itself unconstitutional. And on several occasions, so much was said to describe this case, even this morning, as unprecedented. It's an unprecedented case. It is said to be the first complaint of sexual harassment against a sitting judge in the history of our country. So what? So that we must depart from tried principles of establishing facts? It cannot be. This idea that the identity of a litigant is a judicial way, is a justification for departure from tried legal principles, is a dangerous route to take. The idea that law is an elastic that we must pull to where we want is itself a plague in society. We must be fair, we must be strict about defining things, and we must not allow false or malicious claims, because that would be dangerous to future complainants. As we show in these heads, and I want to, the description of the litigant being a judge is unhelpful in determining whether the factors that constitute sexual harassment are present. They are not. Zero. And we start the overview to show this, which was my second topic, with a legal doctrine, res ipsa loquitur. And I use this, although it's a Latin term, but it's a legal doctrine. It's a Latin phrase for this. The thing speaks for itself. Now, this principle is more important when we are analyzing conversations between people who say and mean what they say, and say what they mean. We keep vacillating from whether a woman can say no, and no means no, to a point where we are not sure if yes means yes. And it's because we lack intellectual honesty to deal with this, so that we can cut out possibilities of sexual harassment that is clear, where people are exercising power to prejudice others, men or women, but largely women. But we must never, in our determination of any matter, sexual harassment, murder, or anything, reach a point where we are not rigorous, because we fear that we will be called misogynist when we are thorough, we will be called brutal. It is actually the brutality, the rigor that we must apply that will determine what it is. And the first thing is to look at what happened.
I must say this. When you talk about the no and the yes, I think the record will show. I asked Dr. Vettel, a no from a woman means a no. And she quickly said yes. And then I said, conversely, a yes from a woman means yes. She hesitated and gave, and the record will show, and gave a qualified answer to that.
Yes.
Surely a no is a no, a yes is a yes. And we must respect both, isn't it? We must, where a woman has said no, we must respect her intellect and capacity to understand that and respect her decision to say no. Equally, where she says yes, we must respect the yes and not rationalize it.
Chair, I was going to use that example, but I mean, it's a question that was asked, and I must quickly add to this question, because I know what the groups that condemn us for brutality will say. You see, it's not untrue that in where power relations are unequal, people use that power to force others to do things they wouldn't do. That's why the definition talks about an adverse and hostile environment. But it's not there for the taking. Your objective facts must show that that power was abused. The fact that that power exists on its own does not demonstrate its abuse. And what we've been told here several times is that the power relations are unequal. But of course, they are unequal. My wife is not a senior counsel, I am. The power relations may be unequal. What you must determine is whether there are objective factors before you that demonstrate that that unequal power relations, if they are unequal, was abused to create a hostile environment. None of that exists throughout this conversation. What is there is a reconstruction, reinterpretation of what she may have meant. And I say this with all due respect. This tribunal must deal with this with all the truth and the facts that are there. If the chairperson asks me, for instance, I make the submission that I think in the face of a very hostile situation, not environment, and many people expected the respondent, actually, and most husbands would have, to duck and dive on these issues because they are embarrassing. None of us in this room would like our WhatsApps to be read, even to our wives or husbands. We wouldn't. So it's an embarrassing environment already. But, except maybe for one incident, I think the JP entered the terrain. Yes, it may be called arrogant, bullish, whatever. Well, this is the environment. But the fact of the matter, he cannot be accused of being evasive and lying. Not once did he deny that he wanted a romantic relationship. Most people would have denied. Most in this room. He would have ducked and dived. I'm not even certain that he dealt nicely with the question of the banana peel, but that's just me. I just think we must be able to be honest about shortcomings in a case. But the general tenor of this, between these conversations, if truth be told, is conversations between two people. Things may have gone sour, but we have no evidence why they went sour. And at no point can one, on the objective facts, without interpreting biblical meanings, that there was a rebuff, that someone was told, don't. And I mention this because a lot, we are presented as some kind of, there's an undertone from us of misogyny, whatever it is. It's not. This case is about finding out what exactly was the conversation about between the two. We may find their conversation disgusting, but it was their conversation. None of them was forced, and it's immaterial who would start the conversation about sex position. It's about what was the tenor of their conversation. Is the unwillingness there? And we will say that it was not. We also state that when the complainant filed the complaint, the pattern of what he did not reveal is curious. And the suggestion that we mean she must have put everything is itself incorrect. That's not what we're suggesting. But if you look at the pattern, it is where she herself is being flirtatious or agreeable to the flirtations that is not put up. The chairperson asked the question, what would have the JCC done had those been put? We don't know, but they would have been better equipped to determine whether there is a case to answer or not. And it's important for lawyers, for complainants and everybody involved in litigation. I think you don't have to be a lawyer to know that truthfulness is correct, is a virtue. You don't need a lawyer to tell you that when you are reporting something, try and disclose something close to the full conspectus of what happened. So the idea that because there were no lawyers somehow diminishes the ability to tell the truth is itself a bizarre suggestion. And so we say that the text messages themselves do not reveal unwillingness. Annexure K8, I deal with this because it's one of those areas about which I think my client has gone through serious embarrassment, purporting to be a picture of the alleged private part. He's still insulted on this, called by this, something no evidence was shown. And we don't make this point to trivialize a complaint or to threaten future complainants. Future complainants who have a legitimate case and know that something like this happened to them will state it. We state that no picture of that nature was sent. The tribunal will remember that I asked, and I reference this later. First, no picture of this nature was sent. But let's ask for a moment if it was. Had it been? And I asked do you know his private part? And the answer was no, correctly so. Because there would be a difference between sending a sordid, crude picture of a penis, a private part, and sending his. And where I fault the complainant, and it's no attack on her, and that's why I removed the word dishonesty, and all I'm saying is that if both, and I said it at the beginning of this hearing, that both the complainant and the respondent will never be the same after this. Because a private conversation between them made it to the public domain. Both of them. And it is subject to being judged. But it's also replete, well, not replete, it has occasions that did not happen. And how do we know they did not happen? First, we deny them. Two, the accuser cannot show them. Nowhere in these proceedings. So the respondent, as I said, never requested nude pictures, for instance, of the complainant. Not once. We are told that he asked her to show umtla, which is the upper body, and I think that's there for itself. And what is important is whether that conversation itself was a conversation that meets the requirement, the factors of sexual harassment. We say it doesn't. No matter how disgusted we are about the conversations, those of us who are perfect, no matter how unhappy we are about the inelegant way in which they were presented, no matter how many high horses we ride from our moral place, the fact of the matter is that that we are not happy with how the two conversed is not an issue for this tribunal and was not an issue for the JP to meet. So my suggestion is that the entire conversation, the general tone of the conversation, the content of the conversation reveal two willing adults who are engaging in something that most of us may find maybe we don't like, but consensually they engage in it about sex positions, about all sorts of things most of us pretend we wouldn't do. That is not the case to determine. And of course, the other point, we've been accused of abusing culture. There's no abuse of culture. It's the point I made earlier. It is difficult to analyze a community of people from outside, first thing, when you are not in that community. But it's worse if you assume superiority of your own culture and way of doing things. It's what we say in our heads. One of our criticism of the expert and how this case is run is to pretend there is a universal truth about which everyone can agree about coaching and fletching.
Mr. Sikakani, I only want to ask, this was never put to Ms. Mengo. She was never granted the opportunity to deal with this cause of culture. And I accept that it's different from any other culture. I accept that, but it was never put to her, and she never got the opportunity to tell us what she knows about it.
I think you're right, Judge. And this is the area where I'm analyzing the expert. That the expert, you will recall that when the expert was introduced, the evidence leader told us that she tried to find a closer culture person. And so the significance of that submission is that that was correctly so with the evidence leader, because she has kept very professional about what she's saying. Correctly, she understood the danger of entering a different culture from a position of knowing the universal truth and being superior about what must be done. And so I accept that. And you will recall that when I tried to engage Ms. Mengo, which she was doing perfectly, I was stopped from getting into this area of power relations with her. I was stopped because I must do that with experts. And so I'm critiquing the expert on the question of culture. And it's not a fact that must be put to a witness. It's an analysis of experts and her legal representatives. And I accept your proposition that it was not put to her. And I'm saying that there was no need to put to her because it's not a fact. I was not putting a fact. It's an analysis, a cultural analysis. We were bombarded with a so-called expert on power relations. And so one has to engage with what I think are inchoate conclusions on this question, on culture. And I know that culture and all sorts of, and religion are used to defend some of the indefensible things, but this is not the case here. This is not the case here. We were not, and that assumption that there is a culture that inherently in it there is some abuse that gets used is untrue, is prejudicial. And so we suggest, we submit that there was lack of rigor. The chair will, the panel will remember, I had to remind Ms. Vetten of the paper she quoted. She quoted a paper that I knew more than she did. And I was demonstrating to her that this is a serious case about which you do not become flippant about what you quote. And we are told later as well that at some point of the conversations, the complainant amassed courage to confront the respondent. Now, how do you assess that this is implausible? Is that you've got to assess the point of when this courage visited her and what happens thereafter. But if you look at what happened is that at the time of this attack of courage, it comes and then it goes. And she continues with discussions with the respondent that are still sexual, flirtatious, and in our view, consensual. And so we submit that the complainant could not explain how her newly found courage quickly dissipated, and they continued with discussions that are flirtatious. One would expect that once someone has made up their minds that this ends and stops here, because I don't like it,
You are referring to
the East London.
the period after the rebuff of intimacy.
Absolutely. Is that, quite frankly, it is condescending to suggest that at all times when we deal with these cases, there are moments when we must regard the woman as some kind of child that is unable to stand her ground, and sometimes we must believe her. I think the objective facts will show when a woman or a man, usually women, are in that situation, we would not be guessing as we are doing here. It becomes very clear very early that we say somebody persisted, and therefore, because they persisted, even if the persistence was not unwanted, constitutes sexual harassment, is an abuse of the legal principle. Because persistence or persisting itself cannot be isolated from the important fact that this was unwanted. Or this was consensual, I'm sorry. So her version that at some point she rebuffed is not borne out by the facts of this case at all. And the last issue in my summary of this is it's difficult to deal with the so-called incident of the 14th or 15th of November because we prevaricate. We don't know whether it's the 14th or it's the 15th, and we are told it doesn't matter. But it does. It does if one reads the entirety of what was presented to demonstrate the whereabouts of the complainant and the respondent. To say we must guess and suggest what is probable is a principle we must apply if things are unclear. The accuser has not placed before this court evidence that what happened, what she claims happened. The evidence of the footage does not show, even if you wanted to do on a balance of probabilities, that it happened. It was submitted here that because we can't really know, we must assume that there is a space there where an opportunity of it happening is there.
When the secretary must have gone to the toilet.
Yes. I think it would be a bad precedent, frankly, Chair, to decide in a matter of this nature that we must decide on somebody's guilt and impeachment from their career on a surmise. Well, because there is this time you could have done this horrible thing. It's unfair to everybody to suggest this is gross misconduct claim for which the complainant and her legal representatives want his career to end. And I think if his career must end, it must end because objective facts and evidence are there so that we don't regret later. Nobody must be sexually harassed, but nobody must be falsely accused of sexual harassment by two adults who may have changed their mind post facto. Another misconception that is here is that we must ignore I was stopped by the chair during the cross-examination when I was painstakingly showing the similarities between the initial complaint, so-called initial, and the complaint before us. To reduce it to that it shows that she remembers because she is consistent is truly something that deserves no response. The point we were checking at that is that she had first said she had no access to the initial complaint. And And when I took her through not just grammatical errors, spacing, full stop. In fact, I was going to spend the whole day doing it until the chair stopped me because it was so identical.
Were you surprised that I stopped you?
No.
You even showed a misplaced full stop. In the one document was equally misplaced in the other document.
Absolutely.
So-
Chair, and what it demonstrates to us, and we must be truthful about these things. And if you place to me something that I think my client didn't handle well, I'll tell you. I've already said there are one or two things like I thought I wouldn't do, I wouldn't say this. But I think it's important for this to realize that first lying or telling a falsehood to a tribunal in a matter of this nature is itself inimical to constitutional values, because so much can happen out of this case. So much. Somebody's case may end. Career may end. And it is equally important that we are fair to the complainant. I'm not asking that she must be ignored and that future complainants must be frightened, but I'm asking that rigor must never be taken out of legal processes because we fear that certain groups will attack us. In fact, the best way to protect this is to demonstrate to both potential harassers and potential complainants that this is a serious matter about which nobody should come unless they know their story. And no respondent, including my client, no respondent must come to be evasive. And I deny the fact that she was evasive. He was embarrassed, but advised properly, and he did it himself, that he will speak the truth about what he did and what he meant. And lastly, the invocation of power dynamics is a range topic that we deal with. And I think I don't deny, no man must deny that power relations are a factor in harassment of any kind, both sexual harassment and harassment in general, in global politics, in personal relations. But to assume that at all times, power relations must dominate how we assess evidence that is before us is itself a dangerous approach to determining cases. There's a big case in this country where a determination is made by describing that the litigant is such an important person. We already have a case like that. Therefore, we will depart from tried principles. And I think it's for that reason that I emphasize that we stick to what is objective, what was put before this tribunal. Because it is only through that we can reach the other point, whether the conduct was honorable, whether it's conduct unbecoming of a judge. You must first, on what is before you, determine whether the gateway to that honorable, dishonorable honor, which is sexual harassment, has been met. And so in pursuit of these allegations, so much is said about the respondent that he behaved indecently. We've put in enough to show that nothing was shown in this regard. And so we demonstrate that this complaint of sexual harassment is entirely contrived. And this statement must not be misconstrued as undermining what sexual harassment is. My learned friend already said, nobody is saying that relationships in an environment of work should not happen. And I think linked to that is that nobody can suggest that flirting in a particular environment, any environment, is impermissible. What is impermissible is an abuse of power to get what you want by force, creating a hostile environment and doing it in a way that's unwelcome. If you meet that, if you find, Chair and the members of the panel, that these conversations were unwanted by Ms. Mengo. And the evidence shows that they were unwanted.
And the respondent persisted with them.
And the respondent persisted with them. Of course you have to find that, because that's the clear definition of sexual harassment. You know, there's no way of me running away from that legality because I want a client to survive. The fact of the matter is that there are things, if the objective evidence drives you without being selective, you see the problems that this case is argued. Sometimes we must look at the context, the entire conspirators, and when you're there, you are told, yeah, but there may be a no somewhere in between. Don't look at the entire conspirators. The fact of the matter is this: objectively assessed, if this tribunal finds and pulls out clear rebuffs, communication to the respondent that I do not want you to continue with these conversations. If you find conduct of that nature or statements of that nature, you must assess them carefully and rigorously. And of course, if you find that they were unwanted, it will be difficult for you not to find that sexual harassment happened, because you're right within the frame of the definition. It would be dishonest of me as a lawyer to try and wiggle out of that. All I'm saying is that the tenor of these conversations, broadly analyzed in their context and objectively analyzed on the content, on their content, do not demonstrate unwillingness. And if all the things that are quoted, some biblical, the eyes and all of this, if they are interpreted to mean these conversations of people who were melting, who were choosing sexual positions to each other, were not consensual, we're in a dangerous path. We're in a dangerous path about future determination of matters of this nature, which are very serious. And so, as I said, the complainant dedicated several paragraphs to demonstrate that she may have rebuffed, she meant this. When she said hi, she meant this. We submit that nothing in the conversation objectively looked at, you don't have to reinterpret or reconstruct them, demonstrates a rebuff. Nothing whatsoever. And where I say both the experts, in my view, and I think I put this to them, the role of an expert is to truly assist the process. We could have found a witness, a misogynist male who wants to come and defend another man. It wouldn't have worked. We could have found a professor who probably would come here and be disgusted about this complaint. That's not what an expert does. And it's for that reason that we could, as much as we try, to find someone who would assist is difficult. One gets tempted to find someone not to assist the process, but to assist the client. And my suggestion about Docrat, and it's said, I'm not talking about them in their absence, is that we find that their evidence leaned not in favor of the process, but in favor of reconstructing a case for a litigant, for a complainant. And so
it may be argued that regarding Docrat,
yes,
to some extent, less so.
Chair, I
Some
think so.
extent.
I think so. I think to be fair to where I fault Dr. Docrat, and I don't think one could say it's lack of intellectual dishonesty or anything, is that it's something any expert can do. I think less so for her because, and I think it's the point that was made, is that when you don't have the entire record, that's the first thing. And two, in your attempt, you give an import to an emoji, for example, because that's, as an expert, what you think. But it's not what the two parties understood it to be. So I think her evidence tended to give an interpretation contrary to what may have been the understanding of the parties conversing. So I think less so for her, but I think the... yes.
Let me catch you right there.
Please.
But despite that, at the end of, this was the end of her evidence.
Yes.
He said, however, I will concede that the meaning and understanding of the messages by the parties will be as understood between themselves, not me. Something like that.
If she did...
I may be summarizing her inelegantly, but
Yes.
in the end, she said, who am I to say they should have understood this message this way and that way, if they, between themselves, understood it in this way? So he really considered and
Chair,
stood aside for a while.
In fact, Chair, to be fair, even Ms. Vetton, in the end, she does point out to the weakness of not having seen everything, and she does. I think the both of them, in the end, I think as intellectuals, they both, unlike we lawyers of parties, I think they were able to realize the deficiency of not having the entire record and imposing an interpretation. I think that is where both of them, in the end, I think fairly, looking back at their evidence, were correct. And so, Chair and members of the panel, I will take you to the evidence, but I do not want to repeat it. Is that there is a narrow ambit of the inquiry you must make. And in that narrow ambit, the word who initiates is not there. It has particular factors that you must look at. And I say this because there's a loop. You are forced to jump and look at how can a judge do this? It's not nice. It's not your gateway to that analysis. In order for you to find that the respondent did not court properly, don't know what courting properly would be, or acted dishonorably, you must first find that this complaint meets the definition, the fundamental definition of what he was brought here to answer. That's a fair way of looking at it. If you were to ask me that we must have a theological discussion about what I would do as a Catholic or what a Seventh-day Adventist would do or people of a different sect, it's a debate that we can have. But it's unfair to have that debate if you jump over the definition. And if you fall short on the definition, you cannot move to whether the conduct was dishonorable. Because that analysis is a jump to subjective questions about which nobody in this room is an expert. And as I said, the Constitution recognizes that judges, like all individuals, enjoy the rights first as human beings. And it's not, when we say freedom of association, we're not trivializing this case. We are saying we are in the realm of two adults courting. And so, to impose our subjective judgments is very nice because we are people, we are judgmental, we ride a moral high horse. It's a nice thing to do. It makes us look better than the rest. But that's not the test. The test is a fundamental definition of what he was brought here to answer. Humiliating him or citing things that didn't happen to evoke emotions in society about what did not happen is itself an unjust approach. And of course, we submit that, and we do this from paragraph 32, much more, where we say there is no residual misconduct complaint here outside the definition of sexual harassment. Nothing. And it's for that reason that we actually, when one witness who ventured into character evidence came, our witness, she was stopped. Because she was entering the realm, and I accept this, a realm of analyzing subjective things about a person, about Ms. Mengo. And I think the tribunal was correct to stop it, but that too must guide us in how we analyze this case. We cannot then venture, if we can't meet the definition of what he was brought here to meet, venture into character. So much was said about him and all of this, or about us being brutal. It doesn't help the case. All I'm saying is that there are objective factors to be determined on this. And so, unsurprisingly, as we say in our heads, the Judge President responded to sexual harassment charges only, to that charge. We could have spent time debating other things, and there was no space for that. And there is no, it's unnecessary, it's not relevant, because we're venturing into things that are subjective. The test, as the evidence leader said, we look at, it's objective. We have the evidence. If there was no evidence, you would be permitted to venture into other things of interpreting. But if the accuser is unable, or nobody can place the evidence of what they say happened, it's difficult to charge people with conjecture, not in such a serious matter. Not when we are suggesting something so serious about another human being. And so he was not called upon to meet all of these cases of what is the right way for a judge to court. Can a judge who's judge president court a judge who's not judge president, or someone who's working? It's a different case if we were to meet that, but we're not called upon to meet that. And it's a difficult case discussion to have because it's mingled in subjectivity. And as I said, the act, I don't even want to go to the sexual harassment policy, the recent sexual harassment policy. Because law works that way. There's always an improvement of deficiencies in how we do things. And so to suggest that we must look into a system that is trying to deal with the future in analyzing what happened is a, I know that while it's being used, we are told no, but yes, it doesn't apply retrospectively. But I think even reference to it is immaterial. It's not helpful. And we deal with the cases of Mutata and Hlophe and Kindred, and we think that reliance is misplaced for this case, quite frankly. And I don't want to bore the tribunal with things. We deal with that from paragraph 47 to paragraph 56. And I wouldn't like to repeat it because I've also dealt with what are the applicable legal principles. And I said when I started chair in the tribunal, there are two cases that are interesting to read about this, because it is reading both of them that will guide taking a fair approach to the complainant and a fair approach to the respondent. It's the case that the McGregor case that I talked about. But I think the Amatole District Municipality case that we've cited this, but I will give members of the panel the proper citation. It's here. Both of them are important. I started with the one that defines the scourge of sexual harassment in society. But the Labour Appeal Court in this one, not that it's unaware of this scourge, deals with a complaint that was deficient. A complaint where no evidence of what is claimed happened is shown. a certain Mr. Fredericks is accused even of something as disgusting as one of the things the respondent is accused of here. Exactly the same. The complainant says, no, he called me to his room, to his office and asked me and showed me his private part or asked me to perform oral sex. And the court finds no such evidence exists. Not that the Labour Appeal Court is unmindful of the seriousness of sexual harassment, but it engages on each case on its own merit. That is one of the most cardinal principles of determining a matter, rather than a broad sweep that assumes that nobody in life lodges a false or a mistaken, erroneous complaint. I said in the beginning that I don't want to attack Ms. Mengo, and I keep using these words because it's possible in error to do something. And that case, the Amatole case, demonstrates better because the judges in that case do go to great lengths to describe even the deficiencies in the evidence of Mr. Fredericks. But assessing objectively the entire evidence, the key areas did not happen. They go as far as saying you can't call a witness reliable when they pointed out things that did not happen. And in that case, they find that the fact that there was reference to things that could not be shown happened. Because if we cannot show that something happened, what are members of any tribunal left with? Conjecture. And if we're going to bring conjecture and assumptions as an important component of legal precedents, it's a terrible precedent. And our courts will be imperiled by an approach of that nature. So from paragraph 57, Chair, to paragraph 68, you will see that we deal with just the definition of sexual harassment, and I don't want to bore you with that anymore. And then we deal again with, in 3 topics, we show that sexual harassment claims here are based on the WhatsApp messages, all of which do not demonstrate sexual harassment. Second, we traverse WhatsApp messages and we find no evidence that crude pictures were sent. And the third topic for which no evidence has been, these are 3 legs of this, only 3 legs of this complaint. Text messages, a crude picture, and lastly, the so-called incident of the 13th, 14th in the respondent chamber. All these 3 legs of this case have not been shown. None whatsoever. What we're left with is guessing what could have been. And I submit that you can never decide a case of this nature to impeach anyone when those pillars are absent. And so we deal with those topics, and I don't want to repeat them, Chair, because if you take our heads from paragraph 71, we then quote verbatim, and from paragraph 72, we also deal with concealed messages. We can differ about what the objective or intention of concealing was, but all we know is that in their entirety, those messages about which we've been concluding that she was a willing participant, all of those were not there. This coupled with what I pointed out in the 2 complaints, that in keeping with the theory that the complainant is a timid employee, junior employee who respects authority, in the complaint she removes a paragraph that would have demonstrated her belligerent behavior towards a court manager. And that pattern of concealment demonstrates that every communication or aspect of what happened that reveals what contradicts the theory of a complaint was removed or concealed and put up later. And so we deal with that in great detail until, I think, paragraph 100. And the topic there we deal with is also what we say are contrived explanations of agreed chats.
Sorry, I might have asked this question even before we came here. You know, this case has been heard over a long period of time with long intervals.
Yes, Chair.
Referring to the set of WhatsApp messages described as having been omitted.
Yes.
I know I met them somewhere, but what I want to know for sure is that they were translated or interpreted, all of them. Okay.
Yes. I think eventually they were here. They're here. There's no suggestion that they're not here. But it's not insignificant that a witness does not give you at the beginning everything, that you must extract it like a tooth, either in cross-examination or when the matter goes ahead. The important principle about complaints of such a serious nature is that they must be truthful, and defenses themselves must be truthful. Because anything short of truthfulness in determining a matter of this nature is a dangerous legal principle. It doesn't matter what I think. It doesn't matter what my learned friends think. It doesn't matter who we sympathize with. Lack of truthfulness in determining a matter of this nature is not an insignificant factor in assessing the evidence, because it contaminates. Let me give an example. If the respondent had come here, instead of agreeing that this is a sexual discussion of a sexual nature, as most men I think would have done, to duck and dive, is, yes, this is romantic. Yes, this is sensual. Yes, this is sexual. Because that's the truth. It would have been utterly dishonest for someone who's called a judge president to try and duck and dive. And so truthfulness is important, even if you are not perfect. It's important when you've put a matter before a tribunal to be truthful. And this is no suggestion of perfection. Both these individuals are imperfect, but they're here, and you don't have to be perfect to know the importance of truth. And from paragraph 101,
Mr. Skakani, can I ask you one question? I'm sorry.
Yes, sir.
In the event we were to find that Ms. Mengo, in some part of her testimony, she was untruthful. Let's talk about the second complaint. That she must have had a copy of the original complaint when she made the second complaint. If we are to find that she was untruthful, does it mean then we have to reject all of the testimony, or we have to be selective on each and every item we are called upon to decide?
Thank you. I don't think so. I think it's a tried principle of arguing. It would be absurd of me to suggest that when a witness has in some way fallen short, you must reject everything that they say. I wouldn't say so. I don't think so. But I think what you must do is to assess the pattern. If that kind of untruthfulness is a pattern, well, you must decide as the tribunal, what is your attitude towards falsehood? What is the impact of falsehood in our legal culture? Because once you introduce the fact that it's insignificant to have a pattern of fabrication for a witness, well, you're on dangerous territory. But all witnesses, particularly women in circumstances like this, or anybody, including my client, humiliated, when you are in a setup of lawyers and judges, it's not unknown to panic It's not unknown not to be certain. And so where instances of Ms. Mengo or my client being uncertain, I do not think that is something for which you must reject everything about. I did cite an example. My client talked about, I had thought the banana peel really is a sexual, and she said, no, it's like a chocolate. I was entirely unhappy with that reference, and she explained it later. But I'm saying it's important that we don't reinterpret everything and the truth to conceal, because then it doesn't help the tribunal. All we are doing is just defend our clients. And I'm saying to you that if you can find, for instance, that there is a pattern of lying from my client, you have to reject it as evidence. You have to find that he's unreliable. But there isn't. But there's a pattern in Ms. Mengo of concealing what would have given a different impression. It's entirely false that she didn't have the two complaints. You don't have to be a lawyer to see this. It would be embarrassing for anyone to suggest otherwise. If she were my client, I would have completely told her, I don't accept this. And then from paragraph 101, we deal with the alleged rebuffs. And the essence there is that there was no rebuff, none whatsoever. Everything that is called a rebuff is an interpretation. We need to sit and debate it to agree that it's a rebuff. A rebuff from someone who's being harassed, at some point must be clear. At some point it must be clear. And what we've been doing is to try and reconstruct what she meant when she said "I" and other things. And the no's that we tried to, I'm still waiting, I'll see the 13 no's. But there was no no that actually, or I, that was not subjected to interpretation. And so we have to engage in that to know that a person says no. And the fact that we had to do that means the evidence does not show us that there was a rebuff. And the evidence shows that Ms. Mengo was a willing participant in these sexual conversations throughout. And I cite there that she didn't do, but it's the 8th of June incident, where she too flirtatiously replies. And I say this at the beginning, it is of no moment who initiates. Some ladies do initiate these days, I'm told, and it is of no moment who initiates. The content of the discussion between two people is what determines whether one is being harassed or one is being inappropriate. It's the incident of the 16th of June, which indicates that there was some discussion that were general, that was sort of inspiration. Of course, this is omitted as well because it does not form part of the theory that all that was happening was harassment. It's the incident of the 18th of June where both of them engage in that discussion. We will remember the quote, especially Rento, to which she reacted with 4 laughing emojis. This is no sign of someone who's not consenting. But this is not put. On the 20th of June, yes, it's been trivialized, the fact that she wakes up in the morning to greet him. Happy Father's Day, Jola. We make no moment in it, except that we add that if you look at the entire tone, this is not someone who is fed up or unhappy with this engagement. It's not consistent with someone disgusted and unwilling. And the reference at 24 minutes past 10 about being cute from her. and following something that says, when men are shy, you make me shy, on that day, including a discussion at 26 minutes past 10, where they're talking about East London. These are people who are engaging, and no outsider can interpret it differently. And so, yes, it was trivialized when it was put to the expert that when people are engaged in courting, in discussions of this nature, toing and froing is the essence of the game. It doesn't matter where you come from. Toing and froing. The word persistence is being abused in these cases sometimes. You know, persisting in a way that is unwelcome, of course, constitute harassment. But persistence, pleading with someone on its own, does not constitute harassment. I would not have been born if my father didn't persist. It took years. And I'm saying persisting, not in a violent way, unwelcome way, in certain cultures, in fact, in certain cultures, if you agreed quickly, immediately, prejudice against you is visited. People think you are cheap, you lose. I'm just saying, it's important that you analyze the nature of the persistence. Unwanted, causing an hostile environment. But to generalize that persistence or pleading with somebody is itself a sign that one is harassing, is a simplistic way and unrigorous way of understanding fully how people engage. And on the 21st of June, another discussion happens. We deal with it at paragraph 135, and I wouldn't like to deal with that now. And we deal with those, Chair, up to page, I think, 57. And I would like the tribunal to go through those unless there are questions as to whether, and we put references in those. 1367. 137, yes, sorry. Paragraph 137, sorry. That's on the 23rd of June, right? And we see also a discussion there where they're talking about the blood warming up. All I'm saying is that all of these chats to which we've referred here constitute nothing close to sexual harassment, even loosely defined. And the evidence we've set out there shows at no point, that's why we are at pains in this room, to try and reconstruct, reinterpret, play psychologist to what could she have meant, in what state was she, was he. It's not important to do that when you have evidence, or you have no evidence of what is claimed. Chair, let me deal with the respondent briefly. I submit that in the face of a very humiliating environment I don't mean in this tribunal, of anyone having to accept that a conversation of flirting is made public, the respondent was generally truthful, accepted at all times that she sought a romantic relationship, that the discussions were sexual and sensual. If you have to assess the two witnesses, I think the respondent, on the objective facts and admitting what happened, was truthful, reliable. The questions about other questions that were irrelevant about it, but you are a married man and all of this, I think those were blocked, stopped in the tracks. because we have to look at what happened. And so I think he denies justifiably all the incidents. He denies that there was at any point. In fact, in some discussions, she actually checks with the complainant if she's unhappy. But there is no unhappiness throughout. Chair, we deal with that, and
I don't know how important is the argument that you are a married man in a country where you can marry 3, 4, 5 wives.
Chair, it comes from, it comes from a temptation. It's a human temptation. I'm a Catholic, and I have a temptation to think everybody is Catholic. And so I bring Catholicism as a universal truth when I analyze things. It's a human temptation to assume that your morality, your own morality, your understanding of things is universal. And as I keep saying, it's worse when it's applied from a position of someone who believes they are of a civilizing tribe. The other one is inferior and barbaric. It tends to complicate the subjectivity of things. And you're right, Chair, in an environment like that, someone has to pursue somebody first in order to decide that they want a second one or a third one or a fourth one. As we know, I think we've only gone to 4 as the experience in this country. But my grandfather had 9. I never know. But I think it's a dangerous analysis, and it's an imposition of a particular worldview.
It deals with morality, which does not find. We're not here to deal with morality.
It deals with, but Judge Pretorius, it actually doesn't even deal with morality. It deals with what I call a worldview. Because if you say it deals with morality, inherent in that suggestion is a suggestion that there's something immoral. It deals with a human temptation to refuse other worldviews of how people see the world, the ways of being and ways of saying and ways of doing things. And that's where we are, and that's why we have this debate about some snide attacks on culture and people. It's because basically we are failing to be intellectually rigorous about different facets in society and how people see the world and how subjectively we see the world and how we're influenced by race, by class, by ethnicity, by gender, and by class and who we are. And so sometimes we impose what we think. That's why I said in the beginning, if you ask me, would I court like the JB does? No. Is that significant? No. There may be 2 million ways of approaching somebody. I wouldn't kneel down. I never did. But most people do. Okay, sorry, Chair. I got it wrong. Chair, it's those, and we deal there with all the annexures, with Annexure 8, with Annexure H, H1 and H2, to demonstrate that some of these evidence of the 17th of June, for instance, that there was an image of a man muffing a woman. She relies on Annexure H1, H and H1, and it also makes reference to H2. We say Annexure H, for instance, does not depict what she says it does. And so most of these accusations that are very serious do not find favor in the evidence, and we have to reconstruct it, engage in some psychological gymnastics to get into the minds of litigants, and it's condescending and wrong if the evidence is there or not there. And Annexure 8 as well, we deal with it. We deal with K12 and K11 and 12 that relates to the 27th of June. That's the most important. And this is probably one of the most humiliating accusations, that no evidence was put before this, that the JP sent a picture of his private part. You have to hate him to believe this even when the evidence is not there, because it's the most humiliating accusation against someone, and you can't show that he did. We deal with Annex K13, JP. Sorry, I keep saying JP, but I think you don't lose that title. Chair, may I move to the cases we rely on that I have said? First, I don't want to deal with them. We set out a series of cases that deal with the principles of expert witnesses. And I think I've dealt with Dr. Docrat and Dr. Vetten. I don't want to belabor points about what was deficient, and I do not want to sound like attacking them in any event. All I'm saying is that their evidence fell short of the tried principles for a witness to assist a process of this nature. And so we deal with the different cases there, and we've cited them. I think it's the Kindred case is different because the judge was the employer, actually, that American case, apart from the fact that it's irrelevant and one could look at it if it offered any help. But we've said here, and we know that as much as we accept that the JP is powerful, he is no employer. And that's the difference there about, and the other cases then it's the Price Waterhouse, I would like and the AM and another versus MEC for Health, and the Dupree case. In those cases that we cite, we say demonstrate that both Ms. Vetten, more Ms. Vetten than Dr. Docrat, fell short. And I must say, in fairness to them, is that in the end, I think when one engaged with them, there was some recognition. I think it's because they are more honest than us as lawyers. They were able as intellectuals, when one points out where they fell short, the fact that they did not have the entirety of the record, which would have made their evidence more useful. They did not engage in that. And so we say here that most of it, maybe not by design, their evidence, particularly Ms. Vetten, became nothing but conjecture and her own subjective views, and sometimes borrowing from her experiences in some of the very important work she has done in legitimate cases of sexual harassment. Unfortunately, she was imposing that interpretation in a matter where the set of facts is not consistent with her experience, where women are bulldozed and women have been harassed by people who are powerful in a workplace. All she was saying is true. It's just inapplicable in this case. We all know how women are subjected to sexual harassment in different environments. Unfortunately, this one-size-fits-all analysis by a witness is itself a dangerous legal principle. And so we deal with that, and I do not want to belabor that point. I cite, without repeating, examples. They are not exhaustive of my engagement or the tribunal's engagement with the experts. And I think the evidence there is clear for both Ms. Vetten and Dr. Doctrat. The last issue is, again, I've mentioned this. We deal with this from paragraph 281, page 92 of our heads. It is this incident. It's as serious as the one about sending a picture of the private part of the so-called effect on me incident. We submit, Chair, that if you look at those dates and the vacillation between, it's not insignificant, that vacillation between the 14th and the 15th. We demonstrated that this changes at a particular point. And you see, at that point, it looks like it's a spray gun approach. I'll shoot and see what I kill. For instance, it would be insignificant to draw the distinction between 14 and 15 if on one of those days, at least, there is evidence that something happened. It would be petty to say, oh, it didn't happen on 14, but it did happen on 15. There is no evidence placed before you. To ask you to assume that there was an opportunity that it could have happened is a far cry. And it's a principle that must never, ever be applied in determining whether someone must be impeached or not. And so we submit that that embarrassing complaint about that incident, as prejudicial as it is, never happened. And no evidence was put here that it did. Okay, we deal with that bit towards the end, and then we cite all of those. And we say in the end from paragraph 292, members of the tribunal, that the objective evidence, which is a point I've been making since I started, the objective evidence negates Ms. Mengo's allegation. Nothing before you sustains the three pillars on which the complaint. If you are called upon to decide that flirting is injudicial, that flirting is dishonorable, well, we plead guilty because this was flirting. But you are not called upon to make that. And the two other incidents did not happen. No crude pictures. Objectively, we know there was none. And the so-called effect on me incident did not happen. And the footage does not show it. In fact, it is the respondent who provided his movement on the day to try and demonstrate where he was. He could account for where he was, and to suggest that because his clerk may have gone to the loo, a finding must be made that he did such a despicable thing is a far cry, is absolutely a far cry, because nothing shows it. And we deal with that towards the end, and we analyze Ms. Ngai's evidence, we analyze all the witnesses, and we think there is no suggestion by anybody. It's unfair to suggest that any of those witnesses were lying. Even our criticism of the experts, it would be untrue to say they are lying. I think it's some kind of what I call inchoate analysis of events and less intellectual rigor in assessing what's before you, and probably a human element of having a particular inclination subjectively as a person. Because in cases like this, as we come in, both journalists and all of us, we have a side that we think is right. It doesn't matter what the evidence is. It's the same as what's happening in the country out there in other commissions. People have solid views depending on who they like and whether they are what I call inherent confirmation bias allows them to do. And we must take that out of processes of this nature. And that's why I started by saying, I have to point out, if I'm asked, what was deficient in my own client's evidence. And I have assessed it. You may not like how he quotes. You may not like, some people say he was arrogant, he's bullish. No lawyer is not arrogant. In fact, most lawyers are obnoxious. And so I think it would be unfair to make those assessments in order to determine whether sexual harassment happened. And in conclusion, we ask this tribunal to assess, for the benefit of both the complainant and the respondent, fairly and objectively what is before it, what actually happened. You can ignore my interpretations, but I submit that what is before you does not sustain any of the three pillars of this very serious, very humiliating, sordid saga. And unless there are questions, Chair and members of the tribunal, we ask you to find where the evidence takes you. And in our view, nothing takes you to sexual harassment. It takes you to something that is subjective about what we think a judge should be, what we think a married man should be, what we think a church elder should be. We can differ about that, and how we think people should court. I don't like the way Madonsela courts, but that's his choice. And so I am saying to the members of the tribunal, we do not trivialize sexual harassment. It's a serious scourge. And it's for that reason that I'm asking that you are rigorous in assessing what was put before you. It's much more important than our own interpretations. I submit, therefore, Chairperson and members of the panel, that this complaint does not meet the standard of a legitimate complaint. Thank you.
The tribunal may not release you, any one of the parties, before a certain time. We are not in a hurry to release you, as long as there are some issues we feel need clarification. And to that end, we may have to adjourn for some minutes, cup of coffee, and come back again. But that said, I don't know if, for now, members of the tribunal have questions to you, Mr. Sikakani.
Mr. Sikakani, I'm going to ask you the same question I asked your counterpart.
Yes.
The issue of a photo. Was there any photo from the complainant which was sent to the JP?
That issue is dealt with in our life because it was a photo, not a status picture. It's a photo that was sent.
Thank you.
By him.
By the way, what page of your heads of argument?
Chair, let me check how we if we are going to adjourn, can I come back with
Yeah,
the precise
that's fine.
page where
Thank
we
you.
deal with that aspect? Because I think my learned friend, it's a dispute. It's what it is, and I think the tribunal must find, on looking at it, does our explanation suffice? And if it doesn't, well, it doesn't. But I think it does. But I'll come back with that.
Thank you.
In fact, may I use that opportunity as well, that as much as I said that was the end, to probably confer with my colleagues during the break, and if I have anything to add, may I be permitted to do so. But in case they scold me about the deficiencies in my
Check
argument.
paragraph 110 of your heads of argument.
110.
Yeah, paragraph 110.
It's 1-1. Yes. In fact, I marked it. It's on the incident of the 8th, where the complainant testified that she never sent the respondent pictures directly. But she did.
Okay.
We've set that out. And that it's a dispute, it's a matter, then we've presented what we say in that paragraph. And the witness, the respondent, dealt with this question. And if his explanation is, in the eyes of the tribunal, insufficient, well, a determination must be made, but that's the answer. But I'll deal with it if this is not enough.
Thank you.
I think that's all we can say about
Okay.
it. Thank you.
Thank you.
May I just ask, I know there were some discussions, maybe on different occasions, about the deletion of WhatsApp messages between them. That issue was discussed between the parties. Delete, don't delete. Why did you delete before I read? Delete so that children may not see, and so forth and so on. So I'm asking this question. Was there an agreement between the parties that messages or some messages be deleted?
Chair, can I, broadly, there is reference to where one asks, are you deleting? And the other says, I am, right? Or I do delete, or I've deleted my message, or they go to. I think the only moment for that is that it just shows that both were mindful that their private conversations would be embarrassing if someone saw them. I don't think it's on its own, it suggests anything else, but it's part of what we've submitted. These were two adults who were aware that their discussion was salacious and that nobody wants that kind of discussion to remain on their phone, just in case somebody else sees them. So I think it just shows that there was some meeting of minds until some point when the complainant decided to publish them. But I don't think it's relevant for determining. Yes. In fact, that I've just been shown that there are messages where one asks, are you deleting this? Says the complainant, asking because he says everything has a name. But I'll try and get and the JP says message deleted. I'm not accusing anybody, but what it just shows is that they both did not want this footprint. Nobody does, of a conversation that is so intimate, that is so private. And I don't think that could be used either against one of them. I think both of them were mindful, like any adult would, that there is an embarrassing element in an intimate conversation becoming available for all to see, even amongst people who do the same. And that's what I called, we're all riding a moral high horse because we've not been caught. But generally, people are embarrassed about their private conversations becoming, and that cannot be used against Ms. Mengo only or against the respondent. I just think it's the general conduct when people are engaged in private, intimate conversations.
One small matter. I don't recall.
Oh, by the way, Chair, the other issue I wanted to raise, because it's raised, it's a topic we deal with, but I think it's that kind that because he apologized, he therefore admits guilt. I think it's a misplaced interpretation of an apology. You know, an apology for someone who's a judge, when what they have done may have, not because it's unlawful, but may have offended, or people find it disgusting, or the recipient on second thought thinks this embarrassed them. I think it's a civil thing to do. It's no admission of guilt. Decent human beings apologize.
I was asking about something. In the complaint, there was some reference to 2021. I don't know whether it was meant to be 2022. And then we were told, no, this is a misprint. It should be 2021 or 22. What is the situation there?
Can I, during the break, check that? I don't want to give you a false answer.
All right, please that. Yes, please. We want that clarification.
I don't remember it.
Yeah. Or are you able to clarify that now?
I'm not, but we'll check.
Okay. And is there an argument by anybody that communication between the two parties stopped at a certain point? I'm asking this question because in your heads of argument, you refer to a year's lapse. Can you explain that, please?
Yeah, I think there's a gap in the conversations until November. From February 2022 to November. There is a gap, there is no conversation. Yes.
Let me write that. A gap from
February to November 2022.
Okay. from
2022.
February? Do you have the date?
That's fine. But the other incident where they communicate is insignificant. It was about using the JP's office. But
Yeah.
for relevant communication,
Yeah.
we say there is a gap of these kind of conversations from February to November
That 20,
2022. February 2022 to November 2022.
22.
Yes.
Is he giving you instructions?
No, Chair,
All right.
she was reminding me of something, but I think we've covered. I think there is that gap, but there is a communication about an office using chambers, but I don't think it's significant in any way.
Advocate Bartlander? Or should I perhaps start with you, Advocate Scheepers? In possible response to some of the issues raised by, which are new?
I don't have a lot because I know Advocate Bartlander has a few, but I think there's only one thing. It's not correct to say there's no evidence supporting the complainant's version that the disputed messages was sent. She testified on that. So that is evidence that must be taken into account. And it's not correct to say that Mr. Moller's evidence does not prove the fact that it was not sent. It also does not prove that it was sent. It's neither
Yes,
here
no,
nor there.
No. But that was in response to Advocate Bartlander's categorical statement in which, in her heads of argument, she says, the evidence of Mr. Moller supports the fact that supports the complainant.
Yes, but it was now argued that there's no evidence that the messages were sent. That is not correct because there's viva voce evidence on that by the complainant. There's no
Yeah, well, we're
proof. I
talking
agree
about-
to the fact that there's no concrete proof. But Mr. Moller cannot say whether or not it was sent because he cannot say from the evidence that he has here who is the sender and who is the receiver.
Yes, but
because
then
it was deleted.
should we say that Mr. Moller's evidence supports the complaint?
I cannot say that it supports it, but it also does
think
not
that's the issue.
disprove it. Yes, it's neither here nor there.
Well, it's a matter for consideration. Advocate Bartlander, anything that arose from the heads of
Yes.
submissions?
Yes, Chair, just a couple of things. But before I do that, I understood that Mr. Skakane wanted to perhaps keep going if he took instructions.
It's finished.
Are you finished? Happy?
Yes.
Okay.
I am.
Chair, a few things. The first thing is I had referred the tribunal to the Judicial Services Commission Act and what's required of a complainant. The relevant provision is section 14 sub 3, which requires a complaint to be made on affidavit, must set out the nature of the complaint and the facts on which the complaint is based. That is the requirement of a complainant. Mr. Skakane in his address referred to this issue of what was attached to the complaint and what wasn't. And he suggested that the additional WhatsApp had to be extracted like tooth. There's no suggestion that anything had to be extracted like a tooth or otherwise. It's not an accurate reflection of the facts. What happened is Ms. Mengo was asked for her phone as part of these proceedings by the evidence leader. She provided the phone. In fact, she preserved the evidence for this process. The Judge President chose to delete all the evidence. One might ask what was there to hide if this was purely a consensual, flirtatious relationship? Why delete everything? But the simple point is there was no pulling of teeth. There was no difficulty. She was asked to provide her phone, and she did. On the question of deleting, which came up just towards the end of my learned friend's address, my learned friend suggested that there was agreement between them that they would delete. There was no such agreement. The Judge President asked her if she was deleting, and she said she was, and that he asked at several points. And the first time she said yes, because I don't have space on my phone. And the second time she said yes, but in fact she did not delete. She'd never deleted anything. It's all there. So when one looks at the WhatsApps, you see that the deleted messages come from the respondent, not from her. He would send a message and then immediately delete it. And in fact, she asked him, why are you deleting? But there was no agreement between them that they would delete this. And so the suggestion that there was some kind of a meeting of the minds on this is not correct. In fact, it's a reflection, I would suggest, of her knowing that there was something in those WhatsApps that he was doing that was wrong, that she was preserving. She was uncomfortable with this. So there's no agreement. On the issue of culture, we're now told that the cultural argument is not a factual argument, but it's an intellectual one, and that's why it didn't have to be put to Ms. Mengo, and that it amounts to our response to the cultural argument amounts to cultural superiority. But in that very context, we're also told that we didn't have to ask Ms. Mengo for her views on this. We are accused of treating her of infantilizing our client, but we are the ones saying she must be asked. What is her view of her own culture? What is her view of the culture that she's supposed to have been, a cultural practice she's supposed to have been participating in? So there's a great contradiction there. Why does only the Judge President get to explain to this tribunal his views of the cultural practice that he says they were both engaged in? Why was she not given that opportunity? It's not sufficient, I would submit, to say that this is not a factual question. It is a factual question. And it should have been put to her, and it was not. The effect of allowing this defense is to say, in the absence of her commenting on it and being given an opportunity to comment on it, is to say that this tribunal must rule on a question of what is said to be her culture as much as it is his, without her even being asked. So let's be clear. Our submission is this argument was an afterthought. It was not raised in the respondent's affidavit. It was not before the JCC. It was not in these proceedings until the very last witness brought by the evidence leader. So we would submit that there's no merit to the argument. Mr. Skakane then says that it's unfair to make these decisions on probabilities, and it's a principle that must never be applied. But that's precisely what the Act requires this tribunal to do in Section 26.3, is to make a decision on the balance of probabilities. It's a civil standard. There's nothing extraordinary about that. You will evaluate the evidence on the facts as they are and make a decision on the balance of probabilities. Then we kept hearing that there is no proof. The respondents kept saying there's no proof. But there is proof. There may not be proof of certain of the explicit sexual photographs. We accept that. But there is proof before you. There's evidence before you. There's an entire file of WhatsApp messages that are the source of the sexual harassment. And one can't throw the baby out with the bathwater. One has to look at those WhatsApps, and one has to engage on what Ms. Mengo says she considered to be sexual harassment. Now, on the suggestion that it is of no moment who initiates sexual conversations, it's correct that that's not a factor in the determination of sexual harassment. That's correct. But it is notable, and it is a factor to be taken into account in determining whether or not in determining the probabilities of what the complainant says. Because if there was just one instance in which the judge president initiated a conversation with a sexual basis, that may be one thing. But where every single time a sexual conversation is started, is had between these two parties, it is initiated by the judge president, every single time, then that's something that gets us much closer to sexual harassment. It's a factor then that this tribunal must take into account, together with all of the factors that we've discussed today. On the Kindred case, I'm not sure if my learned friend has had occasion to read the case, but the judge was not the employer. The whole point of the case is that the individuals who were sexually harassed were clerks in the court. They were employed by the court system. I'm not sure who it is in the United States, but it's the equivalent of being employed by the OCJ. So they were not employed by him because he was a judge. And the case is relevant because it concerns the relationship between a judge and his subordinate, who was an employee of the court. So in addition, the allegations against him were sexual in nature. They involved the sending of sexual text messages, and the court found that he was guilty of sexual harassment. He resigned before the next stage of the process took place. Those are the issues that I would like to address, unless there's anything else from the tribunal.
Sorry.
Thank you, Ms. Patlender. Just one question. I already asked you that question. The 11 no's, where are those 11 no's? Are they the highs, or when you say the 11 no's, where are those on the WhatsApp?
We'll provide you with a list of all the instances that we count.
Okay.
They are not just high. They are all the instances in which the complainant rebuffed the respondent, either by saying no, specifically using that word, or by saying hi, or by referring to a Bible verse where the first word she pointed to was no. Those are all the instances in which we say, she was trying to say to the judge president, I'm not interested in this. But we will put that into a table form and provide it, and I'm sure if the respondent wants to respond, that he would be given that opportunity. Thank you.
Sure.
But it won't be argument that we present. I would literally list the instances and the reference to the papers, unless the chair would like something different. Okay.
Perhaps what we would like to raise, perhaps may be a question to you, Mr. Sikakane. Because you said something about what the respondent is facing or not facing. This this advance which the respondent initiated was during working hours and at a workplace. Shouldn't that be frowned upon, irrespective of whether subsequently the complainant agrees to the advances? Shouldn't that be frowned upon if the Judge President makes advances to the complainant at work during working hours? If that is frowned upon, that may be the next leg in which you may participate. Advocate Bartlett and I may also participate. Would that in itself be, if that is a misconduct, but would that amount to a gross misconduct? And if you're ready to answer that, if the parties are ready to deal with that, please do so. But if you want us to adjourn for 5 minutes, we'll do so. But that is the thing that we want to ask you, that forget the fact that it was the Judge President. We may even ask the question, would it not be frowned upon if a manager makes advances to another manager at work during working hours? Would it not be frowned upon if Ms. Mengo is a clerk, isn't it? A judge's clerk. If another clerk, a male clerk, equivalent to Ms. Mengo, would it not be frowned upon if that clerk makes advances to Ms. Mengo at work during working hours? Consider it, leave out the question of power relations. Yes, I think that...
Yes, Chair, the answer is no. No, it wouldn't.
Sorry?
The answer that whether the timing when people engage would be frowned upon or constitute sexual harassment, the answer is no. Because something must, I think...
I didn't say it constitutes sexual harassment.
Okay.
I said
frowned upon.
Even if it's frowned upon, it may not amount to sexual harassment, but at worst, maybe misconduct. But I said that I didn't opine that it could amount to
Sure.
gross.
I get you.
Yes.
Yeah. Chair, I think the timing of when people communicate, I know that some argument was made about if it's after hours, that communication is inappropriate, therefore it must be within hours. I think the timing of when people engage on its own is of no significance. What is of significance is exactly whether that communication interferes with their function or is an abuse of time, resources, and power. But whether someone sends a message that says you are cute at 8 in the morning or sends it at 8 in the evening, I do not think that debate about what's frowned upon is of any significance about the timing, unless it interferes with time and it creates a particular work environment that is defined as hostile.
Yes, but I think I should mention this. I went through the messages, WhatsApps that were exchanged and the like. I can't even count them. But there's one thing that struck me about this. It's that 99.9% of those messages were exchanged after hours. Anybody can go and check. 10 o'clock, 9 o'clock, early hours of the morning by both of them. But outside working hours, I've looked through them. And I recognize that fact.
Sure.
But the point that I was asking was, you have spoken to it, was the concern that irrespective of whether the JP or what, is it right to take the time at your disposal at work to make that kind of approach? Well, you have spoken to it in the way that you have. I don't know whether you still want to add anything before I
Chair,
move to...
I don't want to trivialize it. I think it is, you see, this is why I said when we start looking at how, and I think the sexual policy maybe trying to do that, is that it's difficult to try and look ahead at what is deficient in our definitions of when, and I think we'll keep improving this. What is unfair is to say, to charge people as we think ahead. And I think that charge of what is frowned upon is a subjective consideration. And in this case, and I don't want to make any point about it, yes, they were after work and all of this, but I think what would be important in future is to look at much more clarified, and I think maybe the policy now does, clarified ways of what conduct cannot happen between people who work together and what conduct would constitute sexual harassment. And I think that's why I call some of it conjuncture, is that we're trying to look ahead, and sometimes it's correct, but that's how policy making happens. But to try and speculate about what would be frowned upon in the future must be expressed in policy, because it's very subjective how people frown upon what different. That's why I called it a world view factor. And the things that some of my colleagues do, and I frown upon them, but that's just it is. It's my background, it's my world view. Doesn't make it unlawful. Thank you, Chair. But if you look at those messages, yes, they are after work and all of this, but I don't want to suggest that our case is made by the fact they are after work. I think our case is the fact that they don't constitute sexual harassment. Flirting is not frowned upon. Everyone who condemns it does it. It's not frowned upon in society. We don't like it when it comes out in the public, but it's not frowned upon. Thank you.
Chair,
Advocate Butland.
thank you. It's correct that all of these conversations happened after work hours, on weekends, public holidays. That is the basis. It's a big part of why we say this conduct was problematic. This conduct was problematic because here was a judge president engaging with the clerk, a secretary, after hours, but also starting off that conversation by talking about work.
But
So,
what people do after work, is it any of our business?
but yes, it is. And the code for
If the
judicial...
judge president on a Saturday morning, good Saturday morning, meets one of the clerks at the mall, and then they start talking along those lines.
Yes, there's nothing wrong with that. But that's not what he was doing here. He was engaging in sexual conversation with her that was unwanted. So what matters here that it was after hours is because it took the workplace relationship into that after hours space. So here, she...
No, but they were not talking about work after
They,
hours.
they did talk about work after hours. There are many
But that's not the
messages.
essence of the complaint, is the sexual discussion after hours.
It is the pattern that we say happened, that he would start by talking about work and then move into sexual conversations. So absolutely, it is critical that that happened after hours. It is part of the pattern. But on the question that the chair asked about whether we frown upon something or not, it occurred to me that, one, we're not asking the tribunal to make a conclusion of whether something is frowned upon. It's about whether or not this constitutes gross misconduct or not. But it occurred to me to point out to the panel that to the extent that, that the panel considers that what it has before it does not amount to gross misconduct, but it amounts to misconduct, then it may say so. And that has happened in other decisions of the tribunal. That would then be taken into account by the Commission in due course when it receives your report, and it would then take into account under Section 25B, 20 sub 5 sub B of the JSE Act, to whether or not to impose any other remedial action or remedial steps that are referred to in Section 17.8. So that is also open to this tribunal.
It won't be the end of the matter.
It won't be the end of the matter. Thank you.
I think we are finished with the submissions. We will reserve our report, our decision, and submissions have been made also relating to the issue of the court of public opinion. I think if it is necessary to make that point, we will make it again, that we are going to decide this case in accordance with the law and the facts of this case, and not in accordance with the court of public opinion, one way or the other. We are totally unmoved by the court of public opinion. And there has been, as Mr. Skakani indicated, this way and that way. And surprisingly, even people who were supposed to know better just wrote articles and said something about whether or not somebody is already guilty or is not guilty. But we can assure the parties that we are not going to consider this case according to slogans or not according to slogans, or we are going to decide it according to the law and the facts and the evidence placed before us, irrespective of whatever court of the judgment of the court of public opinion may be. For that reason, we will adjourn and give ourselves time to consider the matter and then issue our report. And that said, it remains for us to thank the parties for their contributions and effort and time in trying to resolve this matter, which is not uncomplicated. Advocate Bartland. Thank you very much.
Thank you, Chair.
Thank you. You are released. Everybody are released. We are just packing our suitcases.